an appeal in the matter of Walter Merricks, CBE and MASTERCARD Incorporated and others, part heard.
Yes.
Good morning, my lord.
Morning.
In answer to your lordship's questions yesterday, we looked overnight at the cases in which Section 12
Yes, I looked at them as well, actually.
and there are four, which
They're all, I think, broadly speaking, they're all sort of inducements of breach of contract and the like, aren't they?
Exactly.
In circumstances where the contract was governed by English law.
That's right.
And therefore the Section 12 argument was, if it's a misrepresentation, it should follow the same course.
Exactly. And there were four cited, as you pointed out, in Dicey. On your desk should be a copy of the relevant cases. There should be a folder. The reason it's so large is the Deutsche and Sebastian judgment, which is about over 1,000 pages, I think.
Oh, it's good. It's Justice Cook.
It was the trial judgment.
Yes.
And the consistent theme, as you...
Council's fault, Mr.
Indeed, obviously. The consistent theme, as you've said, is that where the parties have entered into a contract which governs their relationship, and where the contract provides for the law to be the law of country A, then one of the parties engages in tortious conduct which is said to arise out of the relationship otherwise than governed by the contract, and where the most significant element would be the law would then be country B. In that limited scenario, those four cases, all four, show that it's possible that Section 12 will displace the identification of the governing law in favour of what the parties have agreed. And if I can just show you that...
One of the judgments, I forget which now, actually does in terms, and it discuss the issue as to whether there really, how on earth you get off the ground with Section 12, whether there's a Section 11.2c.
Yeah, so door knock is the one you're probably thinking of. That's the Aikens judgment, where he says that. And what I'm going to show you is his judgment for that reason in Trafigura, which, so door knock was in the bundle, I think, already.
Yeah.
And Trafigura is him actually then doing the exercise.
Yeah, okay.
And the three reasons, just to tell you what we're looking for, the cases demonstrate that the reason country A's law, the one the parties have agreed, displaces is because there is an agreement between the parties, typically in the cases, bar one, a pre-existing agreement that the relationship should be governed by a law of a different country. Secondly, the commission of the tort is closely associated and arises out of the contractual matrix which the parties have otherwise agreed to engage with each other. And thirdly, it said it would be bizarre, as the cases put it, for the parties' contractual claims to be governed by one applicable law and their tortious claims to be governed by another.
Yeah.
And that's why there's that exception. So you asked me what was Section 12 and 11.2c directed at, and that's the scenario we have found.
Yes.
Might that apply in the present case?
What's that, sorry?
Bizarre to permit English law to govern 97.2% and French, German, Spanish, Estonian, Latvian, etc. law to apply.
But no, because the whole point is there's a contractual relationship that's been agreed, and that's why it's bizarre, not because of any practicality or policy reason or case management reason. And that's the essence of this. It's a contractual relationship the parties have chosen.
They choose contract. There is some collateral tortious claim.
That's right. But the point is that there's a contract. The parties have actually specified a governing law to govern their dealings, and then there's a tortious claim. And the reason, and I'll show you the Law Commission report of 1990. The reason, it seems from the Law Commission report, that there's the post-infliction date. Do you remember we looked at that yesterday as to why it goes beyond the date of infliction? And the Law Commission report seems to suggest it's because they're allowing for the possibility that parties might agree a governing law after a tortious act has been committed.
So what part of Section 12.2 comes into play here? Is it that factors relating to the parties include that they have
A pre-existing relationship.
Contractual relationship.
yes, they have a choice of law clause.
Exactly.
I mean, I'm slightly puzzled by that. The party, we talk very glibly about governing law for a contract. I mean, the parties usually choose a law to govern their contract and therefore govern questions such as the interpretation of the contract and any contractual claims. Why, I don't see why it follows, as a matter of law, as you would put it, that there's some legal connection when somebody commits a tort. I mean, they haven't chosen the same law to govern the tort.
Well, in the cases, that may be why there's so few of them cited, and you saw in Dicey, the extracts in your bundle at the beginning, there's a
Yeah.
wealth of cases where
A whole
section...
reams of cases where it hasn't.
Exactly, we looked at those overnight. So we've looked at all of those, and the reality is that there's only those four.
But I'm trying to pick up Lord Justice Green's point to you that where he puts that there's something quite pragmatic about it.
Well, there
You know,
isn't.
and you say no, it's all because there's a legal relationship.
Well, the
that they've
legal,
chosen, but
the
one's
legal,
contract.
the legal relationship is that the commission of the tort on the facts appears to be closely related to the factual matrix of the contractual situation. Or in Deutscher and Sebastian. If I show you, let me show you Traffic Europe.
Misrepresentation.
Exactly.
Or inducing breach of contract, aren't they?
Indeed.
Or both.
And in
So they're connected. So the tort is, as it were, intimately connected with the contract in one
Exactly.
sense.
In a legal
In a
sense.
legal
In a legal
sense,
sense.
So it's a very specific
exactly.
connection, you're saying, rather than simply the sort of pragmatism
That's right.
that lay behind the Lord's question.
Indeed.
What do those cases then tell you about the scope of 12? And there may just be obvious cases falling within the scope of 12.2. What do they tell you about 12.2 in principle?
What they tell you is what Lord Justice Aikens said in Dornoch, which is what my Lord Chancellor had in mind, which is that he found it hard to see how you ever had an application or how you went about finding a scenario where 12.2 would displace the exercise that you had already done
Because
under
you've already gone through the
11.2c.
exercise in 11.2c.
That's right. And that, just to tell you, is a sentiment that you see repeated throughout the cases, including by, I think it's Lord Justice Waller and others throughout the cases. So it's not just Mr. Justice Aikens, as he then was. It's a whole host of judges who take that view. Dornoch is at tab 22. And then and that's because there will be limited scope for it. And what, I don't need to show you the passage, what you will see is that...
You want to look at Dornoch?
I don't, I was going to show you Traffic Europe.
That's the first case.
Yes,
Yeah.
what you'll see is that Lord Justice Aikens, Mr. Justice Aikens as he was, having said it was quite tricky to see a situation, then finds himself applying it in a particular situation.
Okay.
So that is
Right.
the position. So if we go to Traffic Europe, and I'll show you the Dornoch, if I can just get the paragraph reference for Dornoch, is the point I have in mind, and I'll show you that in a moment. So Traffic Europe was a trial of preliminary issues to decide what law governed the issues concerning the claims of the defendant. My Lord Justice Snowden was prescient. It was the Korean bank, Kukumim, against the claimant Dutch company, Traffic Europe.
I'm struggling to find this.
Just behind the
I'm so sorry, it's in the new file behind Dicey.
Right, yes, got it. So it's behind the
just behind the
behind the
extract.
extract, sorry.
And the quickest thing actually, in view of the time, maybe to ask you to read the head note,
Yeah.
and then I'll show you the relevant analysis. So if we go to paragraph 55, please, you'll see at page, it's 1065, the preliminary issue ordered by Mrs. Justice Gloucester as she was.
Yes.
And then one sees the assessment of choice of law beginning at paragraph 76. And you see the citation in 77 of the passage I showed you from Lord Justice Mance's judgment in Morin. And you see the reference then to door knock at first instance, where Mr. Justice Aikins, as he was, says, I added the following comment to this statement of principle.
Yeah.
And this is the most elaborate factual investigation. You then go to paragraph 95.
Yeah.
And then you can see from 94 that the loss occurred in Korea, not Singapore. And then at paragraph 97, the judge analyses the test under section 12.
Interestingly, it says that the factors to go into the balance under 12(1)(b, the other factors can be quite broad.
Yes, I mean, I don't shy away from that, but what they don't include is pragmatism and case management, because that's nothing to do with
Can I ask
the law
why
in
not?
play.
I mean, the
Because you-
concept of appropriateness
Yeah.
is also undefined. Why, in principle, shouldn't something relating to the sensible conduct of a case be relevant? What is the exclusion of that in principle?
Well, the 2 points. One is that you can't choose what law governs the party's cause of action through pragmatism looked at any particular snapshot in time, because of all the risks that I said to you, that it's uncertain. You'll see the Law Commission actually says that this test, limited in the way they analyse it, is too uncertain. It's too uncertain. It's not the way that we analyse the applicable law in this country, and never have under common law or any of the
This
acts.
is statute. I mean, I'm just...
Yeah. And thirdly,
More appropriate is very broad.
but what would more appropriate mean? It would mean if today I conceded a case, a liability in a case, at that point it would be more appropriate that the law was governed by the law applicable to loss. But if tomorrow I withdrew that concession, the law would change. And for example, does it mean that if you've got 10 individual claims, you have to analyse each individually? What happens in each individual claim if it's more appropriate that the law is for them in one or the law is for them in another, because they have different factors on their appropriateness?
So to take this case, if you're right,
Yes.
then limitation is a defence, so you will you'll do a trawl of every country of the EU to find out what its limitation rules are.
That's right.
And you'll then plead every rule which isn't the same as domestic law.
That's right.
And you'll require the tribunal to decide what under Latvian law or Czech law would the limitation would be, and reduce the scale of the claim accordingly.
Yes. But
That's not relevant. That's not
that's not
appropriateness.
relevant, because we don't, well, first of all, it might be admitted, so it may not be a big issue in the case at all. Secondly, it may not govern many cases, so it may not be a big issue in the case at all. And thirdly, we don't deprive parties, because the court would potentially be in breach of the Interpretation Act 16(1), as we'll come on to see, in depriving a party of an accrued limitation right by relying on a statute which didn't clearly do so. And so that appropriateness exercise directed at limitation would take this court into actually a breach of 16(1) of the Interpretation Act and a wholly different breach, which was not intended by this statute, which is why it can't be used for case management purposes. And you see that, for example, in the Law Commission consultation paper that I've also provided to you, 1984, where it's quite clear that you look at each party as a pair, so you don't look at a collective action and analyse one single applicable law. And you see that in the decision of Mr Justice Popplewell, which is also in the bundle, and also I think it's Mr Justice Stewart as well. So that, and the reason for that is that you could end up in a very difficult situation, plus it would be very hard to know when you would do that exercise, because would you do it at the service out stage when you don't really know what's appropriate? Would you do it at the pleading stage, as my learned friend suggests might be possible? Would you wait until after trial? Would you wait till the amount of the limitation dispute came into
Just
play?
fix it at one point, it may be arbitrary, but it's the best available.
But then it wouldn't meet the test of appropriateness, because it would be arbitrary, not appropriate. So that's why I say the statute can't be stretched. What it's doing is, and I'll show you, so if I can just finish this case, paragraph 103 is where the judge finds that the factors are broad. And then if we go to 104, he deals with the legal point on the governing law, and he specifically finds the contractual matrix in which it is said the alleged tort constituting the security claim occurred is a potential factor. So you see the link in answer to my Lord Justice Snowden's point, and exactly as the Chancellor indicated. And then if you look at 112, he also finds that, it's a last sentence, the reason the governing law of the parties' contractual rights and obligations is capable of being treated as a factor connected to a country is because the law of a country is a feature of the country.
But I think, I mean, the answer that the Chancellor gave and you gave to me is because the particular tort that is alleged has some connection with the contractual relations. I mean, to take a wild example, I mean, if two people have chosen English law to govern their contract and they have an argument about who's breached it and who's doing, and one of them punches the other in the course of the argument, I struggle to think that the fact that the contract between them is governed by English law is relevant to determine the
That's right.
applicable law to the question of was it a tort when he hit it.
And that's why, with respect, we've only, and Dicey only cites 4 examples of where the rule has been displaced, and a whole host of others where it hasn't, because you have it's a very limited subset.
Yeah, and you say on any view it doesn't cover sort of subsequent pragmatic considerations. There has to be a real tight nexus between the tort
Indeed.
and the contractual selection of law.
Indeed.
I mean, you get the clue to that point, if you like, at 103, don't you?
You do.
Where he says, if that pre-existing relationship is said to give rise to events constituting the alleged tort in question, then it seems to me
Exactly.
that's
Yeah,
sort of
but when he says give rise to events, I think he's really envisaging a legal give rise to, as opposed to my example where actually
Exactly.
it's irrelevant to the alleged tort.
So it's a sort of misrepresentation or inducing breach of contract or whatever. Yeah.
That's right. And you can see that. I don't want to take up too much time. If you go to the Deutsche case at paragraph 1037, 1037. I'm afraid it's not paginated, so, but it's quite a chunk in.
Right.
Over 50% in. And the heading is the alleged misrepresentations.
Okay.
And it's 1037, and then if he records the 4 misrepresentations, and then at 1042, he raises the question of applicable law and refers in 1043 to section 11.2c.
Yeah.
At 1044, he says it's long been held the most significant element in a misrep claim is reliance and causation of loss. 1045, he refers to section 12, and his analysis begins at 1046, where he says it was no means clear what the location of reliance was, because Mr. Vick travelled the world. So he's actually saying that he can't, in fact, properly undo the 11.2c exercise, but then he finds in that context at 1047 that the law is the law of New York, because the tort's inextricably bound up with the FX prime brokerage agreement governed by New York law. And there's also letters of authority on the trading. So that's the type of case, and all 4 of them are of that ilk. And if I can just make good, I said to you I would show you the Dornot case. We don't have the first instance decision of Mr. Justice Aikins in the bundle. We have the Court of Appeal decision. But in first instance, I'm just going to tell you that Mr. Justice Aikins was suggesting it was difficult to see how there would ever be scope for the exercise of 12 in relation to 11.2c.
Yeah.
And then in the passage you've got in the bundle in the Court of Appeal in Dornot, which is the authorities bundle 22, you have paragraphs 48 and 49 at page 304 of the bundle. Where the Court of Appeal refers to the fact that section 12 is broad essentially, gives the judge a wide remit, that's between lines D and E on page 304.
Yeah.
And it then says the judge did not conduct a separate exercise under section 12 because he said this involved, in this case at least, considering the same elements all over again. Having regard to the way the judge considered the various elements of the tort, I think he was right to say that section 12 added nothing to the argument, and it would, wasn't saying it would never require the court to look at factors which had not been considered under section 11, but simply that it did not add anything to do so in this case. And if I now ask you please to look at the Law Commission report I mentioned, which should be behind Traffic Europe in the new bundle.
This was the Law Commission report that preceded the passage of the 1995 Act.
It did, and I think it's the final report. You can see that from the front page.
Yeah.
I think it says it's a working paper.
Oh, it's a working paper,
Working papers are, even prior to the consultation paper, they are preliminary documents sent out to sort of solicit responses with a view to preparing the consultation paper generally.
Sorry to interrupt, but I think that might be a different document.
It is a different document. So there is a working paper, thank you, Brian. There's a working paper, which is the 1984 consultation.
I think it's after the first case.
Exactly, and then there's
After
the...
Traffic Euro
Sorry, then.
Thank you, and then there's... So I've got the working paper for a different point, which I'll show you.
Oh, okay.
Thank
This
you.
one, is it private international choice of law and tort?
Exactly, and this is ordered by the House of Commons to be printed.
This is the final report.
Exactly, so I think this is the final report. And 3.9 talks about the rule of displacement formulated by the consultation paper, which is the 1984 one. And if one goes to 3.12 over the page, this is the discussion I was mentioning at the time of occurrence. We talked about the reason of the point of infliction being not limited in section 12. And this was, it says, this was intended to exclude considerations of events which occurred after the tort or delict, such as a change in the habitual residence of the party. However, equally, it seems to exclude, for instance, the fact that parties had a pre-existing relationship before the occurrence. And it's our view there should be no reference to the time of occurrence.
Yeah.
And you can see, so you can see that was their focus.
To deal with pre-existing choice of law.
Exactly. So it wasn't, in my, I'm not saying that the provisions aren't broad, I'm not saying it's limited in that way, but what I am saying is you asked yesterday to for me to give you an example of what 12.2, what content it would have on my case. And this is the content I would say is the target, which is borne out.
I mean,
It's a
they
pre-existing relationship, and that's
Exactly.
really picked up by the later cases.
Exactly.
could have said, built into the statute, including pre-existing choice of law, but they did draft it in broader terms.
They've drafted it in broader terms. I think there's a lot of criticism of that, particularly from Peter North in Cheshire and North. There's a lot of criticism of it, but equally it was said that the common law was so inflexible as to give rise to, I think the expression, which is, I think it's in the 84 consultation paper, a preference to the wrongdoer. And they were quite keen to avoid that, but a lot of criticism was made. But in a sense, I obviously have to answer your questions, Marlon, but I don't have to show you every content of it. What I am able to do is show you what I would say it's directed at.
Yeah.
You could say that was the stimulus
Indeed.
for the change.
Indeed.
There was 5 years between the Commission report and the adoption of the Act. Is there anything in the intervening period, admissible material, which sheds any light on it?
Not that I've found, because this was what was on the Law Commission's website, the 2 consultation papers.
But they, of course, they draw the line when the report is published.
Indeed.
Anyway, I understand.
Indeed. And then I've looked at the commentary. Obviously, this is the Act is a long time ago now, so there's a limited amount of commentary, but it's really Cheshire and North.
Yeah.
And it adds nothing to the case law that I've put before you. If I could then show you, please, the Law Commission, the second point I wanted to make good, which is on the relevant factors to be taken into account. So I'd remind you, first of all, and I don't need, I think, to do this, but I will remind you that the VTB case made it plain that there's a distinction between considerations of forum and what can be taken into account on the factors. And that's, again, another limiting point. And that's come from Lord Clark's judgment at 209, because what he said is that Section 12.1 expressly focuses on the particular torts. And the reason that the particular torts can come into play here, and this is the consultation paper of 1984, if we
Sorry,
could...
where are we now?
Right at the very end.
the consultation paper is at the very back, I think, of the bundle. And this is the working paper that my Lord Justice Green, I think, had in mind, which is just simply a consultation. It's not a final report. But if you look at paragraph 6.82, and 6.83, and I think this is in partial answer to my Lord Justice Green, what I was saying in the end of 6.83, a wrongdoer should be able to manipulate determination of the applicable law by procuring a particular combination of parties. And obviously that goes both ways. It's not just the wrongdoer. The fact that you've got a group of individuals, which I think is what my Lord Justice Green's questions are targeted at.
Well, it goes back to the point that we discussed yesterday, that although it's a collective proceedings regime, each claimant has its own claim, or his or her own
Exactly.
claim. And within that claim, there are a whole host of subclaims.
Exactly. And what you can't do, and I think my Lord Justice Green would be less concerned if this was an individual claim and we were saying the restriction of competition is a foreign law, means is applicable, and that's
I can confess I'm not concerned about anything. I'm baffled by this. I don't know the answer, but you get some support from 685, I
yes,
think, which is probably the nearest analogy to a collective action.
exactly. But what I would say, stepping back,
Yeah.
if this was not a collective action, some of the questions that you're asking wouldn't be being posed, because what's driving some of the questions are of concern about the volume and the number of claimants and so on. And that's why I wanted to show you this passage. And also, if I could just show you the Allen case, which is 2015 decision of Mr. Justice Stewart. So that should be, I hope, within the bundle preceding.
It's 2 tabs back.
2 tabs back, exactly. Thank you. And it was a personal injury case arising in a product liability context. So it was an 11.2a case, not an 11.2c case. And if you please go to paragraph 22.6. Which is on page 449 of the law report.
Yeah.
I do not accept that it is a relevant factor that this is a generic liability action, not just a one-off. It's difficult to bring this within the factors that may be taken into account as connecting a tort or defect with the country. And he cites a paragraph of the Law Commission report and also Naranji and Shelbourne at 157. And if you turn the tab over to Naranji, which is a decision of Mr. Justice Popplewell as he was, and it's paragraph 157, which is, again, it's not paginated, I'm afraid. But what you see here is that the passage cited by Mr. Justice Stewart refers to whether the governing law question should be addressed separately or compendiously to 2 allegations of negligence. And he says they fall to be considered separately, constituting as they do separate causes of action with potentially different outcomes. And what we would say is, what that shows you, the combination of that material shows you that it isn't right to approach the application of section 12 on a compendious basis, or to have regard to that type of concern.
And Allen was 10 sample cases being used as a test case for a much, much larger group. This was the defective hip replacement.
That's right,
The hips that corroded. Yeah.
exactly.
Does it make any difference that Parliament has in one sense overcome these difficulties by creating collective action as in effect a single action? You'd say no, of course, but...
Well, in a
is that
sense,
relevant?
I pray and aid that, because had Parliament wished to say, and a single applicable law will apply to these claims, it could have done. It created a regime, but it deliberately created a regime where the collective proceeding, as I said yesterday, is the wrapper, and the individual causes of action remain the same, and there's no indication that, because it's a consumer protection
Well,
aspect.
there's one very simple way of testing that, is that it isn't, as it were, one claim.
Exactly.
Is if you look at it in just in English limitation terms, if half the claim is time barred as a matter of English law, you can't save it by saying, oh, well, it's a collective proceeding
Exactly.
regime, and the other half of the claim is brought in time, and therefore the whole lot should be regarded as brought in time. But
Precisely.
you have to look at each
You have to
part
look
of
at
the
each one.
claim separately.
That's right.
However,
And then finally, I said I'd come back to you on determining the issues arising in the case, which was section 12.1. And we say that means the issues which arise by reason of the allegedly tortious conduct of a defendant. So in a deceit claim, a false representation of facts, a defendant's state of mind, reliance, causation and loss, they arise in the claim. The task is then to ascertain whether it's substantially more appropriate for the governing law for determining those issues to be different than the law one had selected under 11.2c. What's not intended, for all the reasons I've given, is that to say an issue no longer arises if it's conceded or less hotly disputed, because we're talking about what arises as opposed to the elaborate factual investigation or what the tribunal will determine.
Yeah.
So those were my submissions on the construction of section 12.1 and 12.2. I very briefly will just give you, I think, mainly references for the other arguments, which is that we say that in any case, Mr. Merrick's case on causation was not properly analysed by the tribunal at paragraph 92.1 of the judgment. And we looked at the steps yesterday in Mr. Merrick's causation case and the fact that the consumers are the third group allegedly harmed by the tort. And what we say at paragraph 47 of our skeleton argument is that nearly all the features of Mr. Merrick's case in causation allegedly took place in the same foreign country where the restriction of competition occurred. So the tribunal's finding on that was wrong. They held that it was causation was an issue wholly or substantially connected to the residence of the class members, and that was wrong for the reasons we say in our skeleton.
Right.
The third argument we rely on as why the tribunal's judgment was wrong on section 12 is that it was found that MasterCard and Mr. Merricks had no connections to the countries where the restriction of competition occurred. And we address this in detail at paragraph 49 of our skeleton. And we give three reasons there. And in particular, we say that it is wrong to say that, first of all, the merchants had no connection. It was wrong that MasterCard had no connection, and the assessment of materiality was wrong. So again, insofar as the tribunal went through the exercise of section 12 in beyond the way it put the point of the issue of loss being the most important, its assessment of the connections was itself wrong. And then the final point that we rely on our fourth and final argument on section 12 is that the tribunal erred at paragraph 92.3 of the judgment in having regard to the limitation consequences. And we debated this yesterday, myself and primarily my Lord Justice Snowden, because the tribunal essentially said it would be better to have a single law, and therefore we're going to find that for the purposes of section 12.2. And we cover this at paragraph 50 of our skeleton. Essentially, we simply say that that is a completely flawed approach, and actually probably is the best example of why the whole approach was wrong, because this sort of approach takes one into territory on limitation that the court would objectively not agree with, that approach to limitation. The final area of submissions on applicable law is the common law. And may I just very briefly outline our submissions, and if there are questions that the court has, I can answer them, or I can refer you primarily to our skeleton. The common law choice of rules obviously applies for the period between the 22nd of May 92 and the 30th of April 1996. And if I can show you what the tribunal did, it's at paragraph 93 of the tribunal's judgment. And here the tribunal adopts a summary of the rule from Dicey and Morris, which I could just invite you to refresh your minds as to what the rule is.
Yeah.
And it's known as the rule of double actionability, as you'll remember. And the tribunal also noted in subparagraph 2 the exception to the rule. And we have two grounds of appeal. The first is that the tribunal correctly identified in paragraph 96 that the general rule under the common law requires determination of the place where the act was done, the lex loci delicti, but didn't follow the correct analysis of Barling J in Deutsche Bahn, where he found that it was the place of the restriction of competition. Instead, the tribunal found that the place where the act was done cannot be located in a single jurisdiction in this case. And the reference to that is paragraph 97 of the judgment. And we address in our skeleton from paragraph 54 why that is wrong. It's the relevant paragraphs of 52 to 59 of our skeleton. But in a nutshell, we say Barling J got it right, and the tribunal erred in failing to follow the same analysis. The second ground of appeal is that we say that the exception to the rule on double actionability was also misapplied by the tribunal. And we address this at paragraph 60 to 63 of our skeleton argument. So the way that the tribunal approached this was to say, not following Barling J, the tribunal held that there was no single place where the act was done, and then accordingly purported to apply the exception to the double actionability rule. And they summarise it at 93, as I've shown you. Now, the starting point is that the exception is incredibly rarely applied, and we address that at paragraph 61 of our skeleton.
Yeah.
And that comes from Boys and Chaplin, the passage from Lord Wilberforce's judgment. The general rule must apply unless clear and satisfying grounds are shown why it should be departed from and what solution derived from the other rule should be preferred. And that statement was expressly approved by the Privy Council in Red Sea. And Lord Slynn stated that the exception would only be applied only in exceptional cases.
Yeah.
So the tribunal didn't grapple with that. Secondly, the exception involves a departure from the outcome which has otherwise been reached by applying the general rule under the common law, namely to identify the place where the act is done. The tribunal's approach of abrogating any decision under the general rule, so it found that it couldn't find a place, and then to use the exception to fill the lacuna, was analytically inappropriate, because what it was doing was turning the exception into an alternative primary means of identifying the governing law. And there's no approach for that, support for that in the authorities. And then thirdly, the tribunal in any event went on to misapply the exception, and we set out the errors in detail at paragraph 62. And I don't propose to repeat them orally given the time, but we say that even if the tribunal could have got to the application of the exception, it then misapplied it. So on that basis, the simple point is that there was a place where the act was done. It was the place where there was a restriction of competition, which you've seen in the Deutsche Bahn analysis, and all the same points about the errors infecting the 1995 Act analysis apply here as well. If I can be of any further assistance, or you have any other questions?
Thank you. Thank you very much, Mr. Day. This was so true.
May it please your lordships, I'm going to start with section 11, and I want to start by identifying two important points of common ground under section 11. So the first step is to identify the elements of the tort, and the approach to identifying the elements of the tort in this case is common ground. And can I show you the tribunal judgment at paragraph 85? So core bundle, tab 6, page, I have the wrong reference, just a minute, please. So 85 is at page 163. So there was some dispute between the parties as to what are the relevant elements of the events constituting the tort. MasterCard have made a point about pass-on being a distinct element, but that was not pursued in oral submissions. As regards the relevant events, we respectfully agree with the enumeration of the event set out by Barling J and Deutsche Bahn, see para 79 above. So if we can go back to that, please, which is on page 160. You can see that the relevant events were the adoption of the MIF by means of a decision by an association of undertakings, that's at A, the restriction of competition, that's B, and the loss or damage caused to the claimant, that's C. So that's common ground. We're all agreed that that is the right approach in terms of identifying the elements of the tort in this case. The second point is that the next step is for the court to conduct an evaluative judgment to determine where the most significant element or elements of the tort took place on the facts of the case. Again, the parties are agreed on that that's the right test. And your lordships have seen that the Court of Appeal in VTB and in Morin have stated in terms that this evaluative exercise is one conducted by reference to the facts of the case. And really there are two key questions on this part of the appeal. What do the courts mean when they say the evaluative exercise has to be conducted on the basis of the facts of the case? So what are material considerations? And secondly, did the tribunal make an error of principle when it conducted the evaluation in this case? And as to the first point, can we go back please to the Court of Appeal in VTB? So that's tab 25 of the authorities, and if we can take it from page 405, please. Sorry, if you bear with me, yes, 405, so paragraph 148, and you've seen this paragraph before, Mr. Laney took you to it. But let's look again, if we may, at subparagraphs 5 and 6. So once the different elements of the events and the country in which they occurred have been identified, so we've got the three elements of the tort, you've then got to look at the countries in which they've identified, in which they occurred. You've got to identify the countries in which those elements have occurred. The court has to make a value judgment regarding the significance of each of those elements. Significance means the significance of the element in relation to the tort in question, rather than trying to judge which involves the most elaborate factual investigation. Now, the point that's put against me, I'll come to, is that our argument involves looking at the extent of the factual investigation. We say that's not correct, that's not the point I'm making. I'll come to that. But looking at subparagraph 6, under section 11.2c, in relation to causes of action other than in respect of personal injury or damage to property, the applicable law of the tort in question will be that of the country where the significance of one element or several elements of events outweighs or outweigh the significance of any element or elements found in any other country. And subparagraph 6 is important because looking at subparagraphs 5 and 6 together, it's asking the court to identify in what countries the elements of the torts which have been established took place, and then ask in what country does the significance of one or more of those elements outweigh the significance of any elements found in any other single country. That's the approach. And as Lord Justice Green put it yesterday, what the provision is seeking to ascertain is the country to which the elements of the tort are most closely tethered. And if we go on in this judgment to paragraph 155, which is the paragraph that Lord Justice Snowden referred my learned friend to yesterday, we see again in the middle of that paragraph the reference to the evaluation being an evaluation on the facts of the case. So we emphasise those words, which I don't apprehend to be in dispute. But then if we go on to paragraph 157, starting at the bottom of the page, you see that the important elements constituting the tort of deceit are reliance on the misrepresentation and the loss suffered by VTB. There's then a discussion as to where those elements took place, and we see the conclusion of the Court of Appeal was tentative. And as I'm going to show you in a minute, the conclusion of the Supreme Court was not tentative, but we see the reasoning of the Court of Appeal here. So again, identifying the elements of the tort, looking at the countries in which those elements took place, and then saying, well, which country has the most significant elements compared to any other single country? That's the question. And we see the same approach reflected in the Supreme Court's judgment, which is behind the following tab. And if we could pick that up, please, at page 492. And if we look at paragraph 201, which I don't think you've been shown yet, and could I ask the court please to read paragraph 201 and then I'll make a couple of submissions on it. Thank you. So what we see is that the court here is first of all identifying the elements of the tort. And the elements of the tort are the making of the misrepresentation, secondly, reliance on the misrepresentations, and thirdly, the loss sustained as a result. So that's the equivalent to the three elements that we've seen that Mr. Justice Barling found in his common ground between the parties in relation to the tort in this case. Those are the elements of the tort. The court identifies them, and then what it does is...
That's duty breach, so making of the wreck, that was the unlawful act.
That's right.
Reliance is causation, loss is loss.
Correct.
So duty breach and damage.
That's right. And so it's identifying all the elements, all the essential elements of the tort, and then the court is examining the facts of the case to determine where each of those elements took place. That's the next step. And then it decides where the centre of gravity lies. And you can see the conclusion over the page, just above letter D. In these circumstances, there was, in my opinion, no room for a tentative conclusion that English law is the applicable law under the general rule. It's plainly the applicable law under the general rule. And that's what follows from the analysis in paragraph 201. And so the key point here is you look at all the essential elements of the tort, you work out where they took place, and then you work out which single country has the most significant elements over any other. That's the process. And if...
The only difference Lord Clark has got with the Court of Appeal is that he said, you know, sort of get on with it, you know, don't be so tentative, it's obvious.
Exactly.
But otherwise it's so far no difference.
That's right. And my lord, the key point I'm wishing to draw out, and I'll show you how this plays out in the Morin case, and then I'll explain how it plays out in the present case. But the key point is that one isn't asking in the abstract, which is where at times my learned friend's submissions came close to doing. One is not saying, for the tort of misrepresentation, what is inherently the most significant element? And then where did that take place in this case? That isn't the right result. That isn't the right approach. So one is not saying, in the abstract, where you've got a claim for breach of statutory duty, what is inherently the most important element? And my learned friend says, oh, well, it's the restriction of competition, because otherwise you wouldn't have a claim. Well, that doesn't get very far, because you don't have a claim for breach of statutory duty without loss either. So it doesn't help or advance matters to ask in the abstract for a particular tort, what is the most significant element? You take all the elements of the tort, there were three in that case, 3 in our case, and you ask in what country did those elements take place? And then you may have a patchwork of countries or 2 countries or whatever the facts of the case yield. And then you ask, well, which country has the most significant element? So where is the tort most firmly tethered compared to any other country that's in the mix? That's the approach. And we see the Court of Appeal applying that approach in the Morin case, and I'd like to turn that up, please. So that's behind tab 20. And this was a negligent misstatement case, and the misstatement comprised an auction catalogue that was published by auctioneers in England and provided to the claimant in England. And it contained a description of a car, and the claimant then travelled to Monaco, where the auction was taking place, viewed the car in Monaco, bid on the car successfully in Monaco, incurred the liability to pay in Monaco, and the car was then shipped back to England and was found to be in poor condition. Those are the essential facts. And the question was, what law applied to the claim? And if we pick it up, please, from paragraph 14 on page 267, you see that the relevant head of section 11 is 11.2c. And the court identifies the elements of the claim. So the elements of the tort, the elements of the tort of negligent misstatement under English law are 1, the negligent making of an incorrect statement, 2, by A, 2, on which B reasonably relies, and C, it therefore incurs cost. So those are the elements, incurs loss. So those are the elements of the tort that have been identified by the court. And pausing here, there is unlikely to be, in any case, very much dispute about what are the essential elements of the tort, because it's pretty clear as a matter of law what the elements of the tort are in any case, and that's no doubt why it's common ground in this case and why the tribunal reached the same conclusion on the elements of this tort as Mr. Justice Barling did. The evaluative judgment doesn't come in at that stage. The evaluative judgment comes in at the next stage, which is the assessment of significance by reference to where they took place. That's the critical point in this case. And if we go on to page 269, please, and paragraph 18. And first of all, starting with the final sentence of paragraph 18, the legal elements of the tort of negligent misstatement are clear enough. That's the point I've just made. And the new statutory wording requires, of the 1995 Act, requires a value judgment about their significance in the context of the particular facts in issue. So again, it's fact sensitive. And then if we go to paragraph 19.
It's also an evaluation of all of the elements.
All of the elements.
It's plural in their significance. And
Exactly.
Elements, yeah.
And it's only by looking at all of them that you can reach a view as to centre of gravity. So as I say, it's not helpful in the abstract to say, well, inherently, what's the most significant element of this tort, where each of the elements needs to be fulfilled in order to make out the claim. So then you see at paragraph 19, in the present case, elements constituting the alleged tort occurred both in England and in Monaco. But I agree with the judge that the most significant elements occurred in Monaco, and then there's an explanation of why that's so. The making by BBM, through its catalogue in England, of a negligent misstatement, so that's element 1, is of course one essential element. But the element of reliance was present in the form of a continuum of activity, starting in England, but by having by far its most significant aspect in the form of Mr. Morin's presence and successful bidding in Monaco. By the same token, although some loss, again another essential element, was caused in England, the successful bid involved Mr. Morin entering into a contract in Monaco under which he bought and received the car there and became liable to pay there the price and auction premium, which he met by the remittance from the Bahamas. It's his decision on the spot when making his successful bid and his resulting commitment to buy the car and pay that price and premium, which represent by far the major elements of his reliance and the loss caused and claimed in the case. The entering into an adverse contractual commitment involves on its face an actionable loss, even prior to any financial expenditure pursuant to it, which is what happened when he got back to England. There was then financial expenditure pursuant to it.
If I'm understanding the point you're making, I mean, you can illustrate the point you're making simply by saying, say, in a misrep claim like this, let's assume that this claimant read the misrep in the catalogue when it was sent to him in London, but then he travelled to Monaco to look at the car, and he picked up a copy of the catalogue in Monaco again, or there was some repeat of the representation in Monaco. And in a sense, even if you, I think your point is, you don't just focus in isolation on the misrep as the critical element, because it might not lead you anywhere. Because it might lead you, in fact, to there being two misreps, one in one country and another in the second country. And it's therefore you've got to look at the facts, perhaps, as to which is, the most substantial element, which of the events, those two events, those two misreps, was the most significant on the facts of the case. Is that the point you're
My
making?
lord, that's the point, and indeed it goes further. So it's not just the misrep or the reliance in isolation. One is looking at the three essential elements of the claim. So the making.
You replicate it for each of them.
You replicate it for each of them.
But I think what the point you're making is you don't sort of just say one size fits all for every misrep claim. You will always look at where the statement was received.
That's exactly right, and that's why the courts say it's an evaluative judgment on the facts, because if one were just saying, oh well, in a misrep claim, reliance is the most important thing, where did that take place?
It would just be a mechanical exercise.
It's just a mechanical exercise.
It wouldn't be an evaluation at all.
That's right. And that's why we say...
The elements of the tort are the same in every case.
Correct.
That's why the tribunal in this case accepted what Mr. Justice Barding said, and that's not disputed.
Not disputed, it's common ground. Exactly, that's precisely the point, my lords. And so that's the exercise that's being carried out. Now, my learned friend's argument came close to saying, and you'll recall she said, well, it's impossible on the statute to have a different result for the retailer's claims and for the consumer claims. And we say, well, no, not so, because it does depend on an evaluative exercise on the facts of the case. And I'll tell you why I'll tell you why in a moment, why the evaluative exercise reached different conclusions, because there were materially different facts in both cases when it comes to the application of this test. Now, applying this approach to the present case, the first element of the tort in this case is the adoption and maintenance in force by MasterCard of its EEA MIF. So that's the decision by the Association of Undertakings. That's the first element of the tort. Now that took place in Belgium, and nobody is arguing in this case that weight should be given to that, because the fact that the decision was adopted in Belgium is really one of happenstance. It's where MasterCard was based, but it has no relevance to the substance of the tort in the case, which is what Mr. Justice Barling found too. You'll recall that the rival submissions in terms of applicable law that were put to the court, to Mr. Justice Barling, were on the one hand the adoption of the MIF in Belgium, and on the other hand the restriction of competition. Those were the two rival contentions.
The facts have got to be relevant to the tort. The decision finds the first component of the tort to be EEA-wide. And then Mr. Laney puts it on where the merchant's banking facility is. That's one component of the breach, but the broader breach was focused, according to the decision, on the EEA, which is every member state, including the United Kingdom.
Correct. And so, my lord, there are 2 points. So just, and I'm going to come on to restriction of competition, but just focusing on the first of the essential elements, which is the agreement or decision. Here it's a decision by an association of undertakings, took place in Belgium. So Belgium is in the mix, potentially. But nobody says that any significance should be given to that, because it's not a point which has significance on the substance of the facts of the case. It's a happenstance.
Not relevant to the tort.
Not relevant to the tort, where it could have taken place anywhere. They could have had their headquarters in London or in Germany or whatever. So
There has to be a decision on an association of undertakings, which could be inside the EU or outside.
Exactly.
And then there has to be a restriction of competition in the EU.
Correct. So you need it. You need the decision, otherwise you don't get off the ground. But it could be anywhere. So the second element is the restriction of competition. And the place of the restriction of competition is the location of each merchant's acquiring bank. That's the place of the restriction of competition. And again, we agree that that is the place of the restriction of competition. There's no dispute about that. So take a claim of a single class member, resident in England, who made the vast majority of their purchases in England, say 98%, which is generally reflective of the balance here, although I think we're going to agree the precise figure, but it's about 98%. But that class member also made some remote purchases from, say, France, Germany, Italy, Hungary. The relevant restrictions of competition will be in England and in France, Germany, Italy, and Hungary. So there is no single country where the restriction of competition took place. You've got multiple candidates for that claimant's claim. And the third element is loss. All of the loss was suffered in the United Kingdom, in England or in Scotland. And for the purposes, it's agreed that Northern Ireland is to be equated with England. So when one is applying the approach that the Supreme Court applied in VTB and the Court of Appeal applied in Morin, and asking which is the single country where the most significant element or elements of the tort took place, the answer is clearly the UK, England and Scotland, because there is no other single country to which the tort is more closely tethered on the facts of the case. So you have Belgium, which we're going to discount for the reasons I've canvassed. You've then got a patchwork of different countries where the restriction took place, including England and Scotland. And then you've got all of the loss taking place in England and Scotland. And so applying the approach that we've seen, the single country to which the tort is most closely tethered is the United Kingdom. And that's really the answer to the Section 11 point. But there is a further...
This assumes, does it, that there's effectively a single tort?
Well,
what Mr. Laney has done is to say, well, each claimant has a series of separate claims, series of separate causes of action, which are in relation to which he said, well, if it's a transaction with a French merchant, then the applicable law is France, and that's how she gets to that. But you say, no, that may be the position with the individual claims. One was looking at the tort. It's what? That it's a single
my lord,
tort, or it's all the same tort, or whatever.
let me take that in 2 stages, because first of all, it's not what Mr. Laney says in her skeleton argument. So if we look at Mr. Laney's skeleton argument, sorry.
Yeah.
And if we go to
Tab 21, is
so
it?
it's tab 21, and it is here we are. It's page 342.
Hmm.
341. So it's paragraph 58 on page 341. So the tribunal was wrong in the PTA decision to contend that this requires analysing a class member's claim as though it has brought thousands or millions of individual actions. So I think their position is that the proper analysis is that there are not thousands or millions of claims for every transaction. And if we look at how the tribunal, we respectfully say that the tribunal's analysis of this is correct. If we take, it's most clearly set out in the PTA judgment, which is behind tab 11 at tab 12, I think, at page 258. And if we look at paragraph 16, as regards the general rule, so it should be emphasised here that each member's claim lies against MasterCard in respect of all his or her purchases, and the tortious act on which that claim is based is MasterCard's system for determination of the MIF. The class member is not bringing different claims against different merchants in respect of his or her purchases. And that makes sense because what one has in terms of the infringement established by the decision is MasterCard's decision to enact and maintain in force the EEA MIF. So that, the maintenance in force of the EEA MIF, which is then charged by the issuing banks to the acquiring banks, which leads, as you know, the premise for this case is to an overcharge in the merchant service charges charged by acquirers to retailers, which is then passed down to consumers when they make any purchase, not just purchases using MasterCard, but any purchase from a retailer which accepts MasterCard. So it's passed down generally to all of the purchases. And so each purchase is just an instance of loss flowing from the single breach.
You did this so smoothly. I've taken quite a long time to sort of develop the question again. What you said, and I'm just looking back at the transcript, what you said when you'd been through listing the three elements was that when one is applying, this is what you said, I think, when one is applying the approach the Supreme Court applied in VTB and the Court of Appeal applied in Morin, and asking which is the single country where the most significant element or elements of the tort took place, the answer is clearly the UK. Now, formulating your question that way, you focus on which is the single country where the most significant elements of the tort took place.
Yes.
Well, you get to the UK, you say. That isn't what, certainly not what the Court of Appeal did in VTB, or at least it's not the way they expressed the test. I mean, forget what they did on the facts, which we understand the Supreme Court didn't agree with, but when the Court of Appeal in VTB set out the way you approach it, which everybody seems to accept is right. For example, at 155, after they referred to what Lord Justice Mann said in Morin, they say this must mean that the judge has to decide what is or are the most significant element or elements in relation to the tort of deceit or conspiracy on the facts of the case. So they don't formulate the test as saying choose a single country, you know, in the way that you put the submission. They say no. I thought they say you have to look on the facts. What is the most significant element or elements of the tort? And then ask with which country are they most closely connected? Because I think what you might have done, and it was done, as I say, so smoothly that, you know, I wasn't sure that, as it were, I could see how you did it. That you I think may have turned the test round. Now, am I?
My lord, can we go back
can
to?
Can you just go back a little bit?
Of course. So
I'm just.
I understand
just,
the point.
Yeah, and I'm just a little bit too slow, I think.
No, my lord, not at all. And can we just go back to the Court of Appeal at 405, so behind tab 25. And so, my lord, you're focusing on subparagraph 5, but you also have to read subparagraph 6. And what that says is under section 11(2)(c), where the elements of the events constituting the tort, so you're not limited here to some abstract notion of what the most significant element is, take place in different countries, the applicable law of the tort in question will be that of the country where the significance of one element or several elements of events outweighs or outweigh the significance of any element or elements found in any other country.
Right, but they focus there on the significance of the elements of the tort, which lead you to a country. I thought what you had done was to sort of turn the question round and say, which country do the various elements lead you to? I'm not sure that's actually the same exercise.
Well, my lord, can we just look at subparagraph 6 and apply it to how we say it would work in the present case? And so you're looking at, so where the elements of the events constituting the tort. So at the moment, we are looking at the elements constitute, the events constitute, the events constituting, the elements of the events constituting the tort. Now, applying that to this case, what are the events, the elements of the events constituting the tort? So you go back to what are the essential elements of this tort, which are the decision of the Association of Undertakings, the restriction of competition and the loss. So that's your starting point for the beginning of 6. Then it says, the applicable law of the tort in question will be that of the country where the significance of one element or elements outweigh the significance of any element or elements found in any other country. And so what that's requiring you to do, and we see that that's what the Supreme Court does and the Court of Appeal in Morin does, is you start with your elements of the tort, we've got 3 in this case, and you say, well, what are the events comprising them? So the events comprising them are the setting of the myth, that's the first element, that's in Belgium. And then you say, well, what are the events comprising the restriction of competition? Well, that takes place, that the restriction of competition it is a restriction in terms of the price paid to the acquiring bank. So you say, well, where does that take place? And you look at where that takes place on the facts of the case. So that's a multiple patchwork of countries. And then the final element is loss. And so you say, where does that take place? Here it all takes place in one country, to England and Scotland. And so then you ask yourself, okay, so we've determined where the elements take place, and then you've got to make an evaluation of significance on the facts of the case, and significance leading you to one country above any other country. So that's what we say paragraph 6 does.
So you're saying that last sentence, when you unpick it, and it's not an entirely easy sentence to unpick, you say the focus is on the country where the significance of the events outweigh the significance of any elements found in any other country. So you say it is right to, as it were, start with a sort of country by country analysis, rather than focusing on the elements of the effects of the tort, and then trying to get to a country. So I think you say the way you must apply this is to tot up what's, if you like, the balance for each country.
That's right, but you are focusing on the tort. So at this stage, you're not saying, well, how connected is that element to the country? You're essentially locating the elements of the tort in the various countries where they took place, and they may straddle different countries. And then you go back to the tort and you say, well, in terms of the significance of this tort, the elements of this tort, where are the most significant, in what single country as compared to any others, do the most significant element or elements take place? So that's why it's a fact-sensitive exercise. And I agree if you were to read, and I think this may lie behind my Lord's question, if you were to read subparagraph 5 in isolation, you don't necessarily get to the same conclusion, but you do have to go on and read 6, and that explains how this test, which otherwise looks rather abstract, but can't be abstract because we know it's evaluative, we know it's dependent on the facts, that explains how the evaluative exercise takes place. And as I say, that is how the Supreme Court approached it on the facts in VTB, and it's precisely how the Court of Appeal approached it on the facts in Morin. So again, going back to Morin, and I won't take you back to the judgment, but paragraph 119, which I read to you, what the court didn't do in Morin is it didn't say, well, we've got negligent misstatement. We think generally in negligent misstatement cases, reliance is the most important factor. And so where did reliance take place in this case? That's not the order of events. What the court did was looked at all 3 elements of the tort and said, where did those elements take place? And where is the significant element, in which single country as compared to any others, are the most significant elements in this case? And it was Monaco. And that's because the reliance was split between England and Monaco. Loss was split between England and Monaco. But actually, when you get to the heart of the case, the meat of both reliance and loss were in Monaco.
Could I just ask you the facts relating to the first element of the tort, which is, one calls it breach. So breach involves the existence of a decision of an association of undertaking, which is Netherlands. Belgium.
Yes.
Identification of a relevant market or markets, which is national. Delineation of an object restriction, which is the setting of the intra-EU MIF, setting a minimum price.
My lord, here it was an effects case, of course, so the Commission decision.
Effects.
Yeah.
But then an effect on trade between member states, so more than one member state affected. So that you've got a patchwork of different states for element 1, of which one, in our example yesterday, is France, because that's where the merchant is physically located.
Yes.
And we make the assumption the merchant's banking facilities are also located, probably a reasonable assumption. But
Yes.
the first element is quite complicated when you actually work out what the ingredients of breach are, and looking at the actual decision in dispute in the Commission, they didn't define it as one member state, they described it as an intra-EU breach.
That's right, because it was the intra-EA MIF, that's the MIF that's the subject of the Commission decision, and this is of course a follow-on claim. So it's precisely, and the intra-EA MIF applied specifically to cross-border transactions.
Yes.
So not limited to a single country.
It has to. If it didn't apply to cross-border, there'd be no effect on trade, so there wouldn't be a breach. But it's only once you've got past stage, then you then move into loss, and then we're dealing with pass on from, in our example, France back to consumers in the UK, and then you've got loss sustained in the UK.
Yes. And so, precisely, my lord, I agree with all of that.
Well, it's working out what's comprised within element 1, which is important, and whether one just focuses on where the restriction is said to occur, because the relevant market is defined nationally. But the actual element 1 has many different components beyond that.
That's correct, and so it's maybe simplistic. So we've got decision of association of undertakings is element 1. Element 2 is restriction. Does it restrict competition? There, everyone agrees it's a patchwork of different countries because it's where the acquiring bank was located. But you're quite right to say that I've oversimplified point 1, because the decision, of course, needs to have an effect on interstate trade, etc., etc. But the point is, even if one gets into those nuances, you're not led to a single country. So what you have in this case, standing back, is a position where all of the loss is incurred in the United Kingdom. And element 1, the actual decision was taken in Belgium, but we say in terms of the significance of the tort, that's not a significant factor because it's happenstance. It's not connected intrinsically to the tort in this case. And then what you have, whether you're looking at restriction of competition or interstate trade, is a patchwork of different other countries. So when one is applying subparagraph 6 in paragraph 148, and you're saying, well, looking at the elements of the tort, you've got to identify the country where the significance of one element or several elements outweighs the significance of any element or elements found in any other country.
But this, I mean, the curiosity is, I now see the difficulty of 5 and 6. In 5, significance means the significance of the element in relation to the tort in question. So it seems to invite, admittedly on the facts, but it seems to invite some sort of analysis of, in relation to a particular alleged tort, what's the most significant element. And I think what you're saying is, even if in looking at the facts, you would ordinarily say that the most significant element, for example, is the restriction of competition. If that occurs all over the place, actually the applicable law could be defined by reference to an element which you ordinarily wouldn't think to be quite so significant, but happens to have occurred in one country. So, for example, where the loss is sustained, because that's all in England, that might not normally be regarded as the most significant element of the tort. But because that happens to have been in one country, that's going to be the applicable law. And
My Lord,
I'm just not sure that's really what they were getting at.
My Lord, my point with respect goes a little beyond that. So I say, and this really I think is how the tribunal saw it. I think we're really getting to the meat of what the tribunal saw as being the issue between the parties. We say that you don't just stand back and say, well, theoretically or in the abstract, the tribunal used the words in the abstract, what is the most significant element of this tort, and then work out where it took place. That isn't the right approach, because that, first of all, for 2 reasons. First, because it's meaningless in the abstract to talk about the most significant element of the tort, because for breach of statutory duty, of course, you need loss as well, otherwise the cause of action is not perfected. So unless you have loss, you don't have a cause of action. So that's significant on that basis too. So it's not meaningful to talk in the abstract of the most significant element of the tort. So what you have to do is identify the elements, which, as the Court of Appeal said in Morin generally won't be contentious. And then you have to ask where those elements took place. And then you have to ask, right, we've understood where they've taken place. Now, thinking to the tort in this case, where are the most significant elements located? So you've got to choose a country. So you may have...
Yeah, but it's at that stage of the analysis. I think what you're saying is, even if you look at the intrinsic nature of the elements of the tort, you look at the facts of this particular case. If you were to say, well, no, I understand that this tort is all about restriction of competition, and that's really what is said to have gone wrong here, that these defendants restricted competition by their actions. Because that took place across a number of countries, you have to say, oh well, I'll look at an element of the tort which I wouldn't ordinarily think to be the most significant, but because they all occurred in one country, that's going to be the applicable law. And if that's the approach, I don't think it is the approach
No.
you're urging. I think you're shaking your head.
No.
But I'm struggling at the moment.
I
to
think
see
I'm
that.
troubled by the same,
My Lord.
maybe the same point. I mean, if one, looking at it in terms of Deutsche Bahn,
Yes.
if all the acquiring banks are all in one country, so forget the foreign element, that's the complication here. If all the acquiring banks are in England, then what he says is the most significant element is a restriction of competition, and that's in England.
Yes.
Well, if that's right in that case, and then when you come to this case, okay, given that what you're looking at is a one remove because it's a claim by the consumers rather than by the merchants, but if all the acquiring banks were in England, why wouldn't the restriction of competition be the most significant element?
Well, my lord, for two reasons, and coming back to Lord Justice Snowden, I'm going to try and deal with both of your questions together. So, coming back to Lord Justice Snowden's question, that isn't how I put the case. So I'm not saying you identify the significant element at the outset, and then if there's a patchwork, you say, well, let's forget that one and look at another significant element. So I'm not saying that. I'm saying that what subparagraph 6 of VTB says is that you look at all of the elements of the tort. So you're looking not just at restriction of competition. So you're not saying at the outset, well, restriction of competition is the most important element of this tort because it's about competition law. You don't say that. And so you look at the three elements of the tort and you work out where those elements took place. So going back to Morin, what the Court of Appeal did, it didn't say, well, we think the most important element of negligent misstatement of the three elements we've identified is the second one. They didn't say that. They said, let's look where the act of negligent misstatement took place. Well, that was in England. Let's look at where reliance took place. That was partly in England, but mostly in Monaco. And let's look at where loss took place. That was mostly in Monaco and partly in England. And then let's think about the significance of those elements to the tort on the facts and work out which country is most connected. That's how it approached it, and that's what we say is the right approach. That's what subparagraph 6 of the Court of Appeal says. And so you don't, and this is why, coming back to the tribunal, why the tribunal characterised MasterCard's submission as working out significance in the abstract, because on the point put to me by my Lord Justice Snowden, which is not my argument, one doesn't, if one starts by saying, well, what is the most intrinsically or inherently the most significant element of a tort for competition law damages, for breach of statutory duty, well, it must be restriction of competition because this is a competition law case. That's not what you do. And that's not how the Court of Appeal approached it in Morin, not how the Supreme Court approached it in VTB. And then coming back to my Lord, the Chancellor, can we just pick up, it may be easier to do this by picking up Deutsche Bahn, so I can show you the differences.
Yeah.
So if we go to the second authorities bundle, tab 31, well, yours may not be ordered under the same volumes, but it's tab 31, 99, if we start at 992. So we have at the top of the page on paragraph 35 the rival contentions, which is the point I made earlier. So the primary submission of the claimants is that the applicable law is the law of Belgium, and the primary submission of the defendants is that it's the country in which the merchant was based at the time of the event, which caused the MSC to be higher than it would have been. And just pausing here, these were claims brought by individual merchants. So those merchants were based in particular member states. And so for every merchant, there was a single place that was the place of restriction of competition where their acquiring bank was, so the same place where they were based. So that's a key point of distinction with the present case, that because this is an indirect claim, that isn't true of each individual class member in this case. And that's a very key point of distinction when one is applying the subparagraph 6 rubric. Now,
What? Because they're all in the UK.
no, because the loss is all in the UK, my lord, but
Because the losses.
the restriction of competition, the key point is that for each class member in this case, who may have made, as I say, the majority of their purchases in England, but some in France, Germany, Hungary, wherever, the restriction of competition is in each of those countries.
Yeah.
Whereas for the merchant, each merchant was based in a single member state. And so for each merchant's claim, the restriction of competition was in the same place, that it was in one country. That's really the key point of distinction.
Yes, it was a much easier case because, I mean, the assumption being that the merchants' banking facilities were in the same state meant that your centre of gravity for everything
For everything.
was in that state.
That's right. So that's why the claimants didn't want the state of the merchant to be the applicable law. They said it was Belgium. They weren't saying it was loss, because loss was actually in the same state. So for a merchant is based in England. The restriction of competition takes place where their acquiring bank is in England. Everyone's working on that assumption. And their loss is suffered, the payment of the elevated MSC, in England. So it was a much easier case. Whereas that's not the position here.
I'm sorry to rise, that may be entirely my fault, but at the moment we're a bit confused on this side because we had understood below that it was common ground that there were separate causes of action, and so that we analysed the cross-border transaction claims separately. And we also understood that the argument being advanced by my learned friend was to uphold the tribunal's judgment.
My lord, I'm
as
coming
it
to that.
is. But at the moment this seems to be, I'm just putting a marker down, I may be wrong, this seems to be an entirely new case. And so I just would like to see where it is in the skeleton of the respondent's
Really why I raised
notice.
the point, which I did
Yeah.
several minutes ago, about what was being said was that there was one tort,
Exactly.
because it seems to me that that's quite problematic, because on one view, each claimant is the tort, there isn't one tort. It's not as if MasterCard is the wrong, is, as it were, setting out to harm everybody, if I can put it that way.
Exactly.
In a compendious way.
Exactly.
Isn't there a separate tort for each claimant? But anyway.
And what, I'm just putting down a mark because I wouldn't want my learned friend to go through all of her submissions
No,
and then
no,
raise
no,
this and
no,
reply. That our understanding is that the tribunal said that had it applied the legal test in Deutsche Bahn, it would have reached the same conclusion. If my learned friend is advancing some point of distinction that means even if the tribunal had advanced the same legal test as applied in Deutsche Bahn, it should have reached a different conclusion, which seems to be where her argument is, to distinguish it, then that would have required A, a respondent's notice, and B, some notice in the skeleton. So I just want to put a marker down that if this is a new point, which it seems to be, then I'd like that identified. If it's not a new point, it needs to be tracked into the skeleton so we can see how it was put.
Right.
Well, my lords, it's not a new point, because the point that the tribunal, the point of distinction between us below that the tribunal said was significant, which is the significant point, is the question, as the tribunal said, of whether you determine significance in the abstract in relation to the tort, or whether you'd make an evaluative assessment on the facts of the case. And that's the point of distinction between us. And the way that MasterCard puts the case, and the way they put it below, and the point that was rejected by the tribunal, is that one starts with an abstract assessment of what is the significant element of this tort. Now, on their case, if that were right, then for every competition damages case, you would always come to the answer, restriction of competition. And that's not right. That's contrary to the authorities. I'll take you to Protea in a moment, that says that that's not right, that for any single tort you can have different answers.
That's exactly what Mr. Justice Monbrook says.
Exactly. So the point
And
that...
I did puzzle about that yesterday, because it did seem to me that I was struggling to understand how on MasterCard's case you ever got to a different answer in the case of a different MIF case. Why don't you just always get to the same answer?
My lord, that's
On the basis that the elements of the tort are always the same three elements, and therefore by definition you get to the same answer, but that can't be right on the authorities.
My lord, that's precisely...
Was it Lloyd and Google, or was it Merricks in the Supreme Court, one or both, in which they said it's quite possible in an aggregate damages case that you may include within the class people who haven't suffered any loss.
In Merricks, my lord, I could take you.
Merricks, wasn't it?
Merricks.
In
And
Merricks.
that's the nature, that's why this is a revolutionary new form of claim. You may, provided, because you've got an aggregate claim, you don't necessarily dissociate the distribution into individuals. You may just generically supply people, even if it doesn't represent their actual loss, and even if they might have had zero loss.
My lord, that's precisely right, and I'll take you to the part in the Supreme Court in Merricks where the court said that. And of course, and it really goes to the point, my learned friend kept saying, well, the fact it's a collective proceedings is just a wrapper. Well, with respect, that's wrong for the reason that my lord has given. What the Supreme Court said, both the majority and the minority judgment, is that this fundamentally changes the cause of action in tort, both because of the aggregate award of damages, which doesn't follow the compensatory principle for individual claims, and because it can give rise to awards in respect of people that haven't suffered any loss at all, where there's been no, in respect of whom there's no liability. So it's not just a wrapper. I'll come back to that point. But the reason, again, to crystallise the point of dispute between the parties, the tribunal said in its judgment, well, I'm facing two arguments. One is, do you just make this evaluative assessment of significance on the facts, which is the point that we say is the correct position. And they said, if you do carry it out on the facts, you end up with England being the place of loss. Or is it, as MasterCard argued, a more abstract exercise? Now they say, oh, well, it's not abstract because we accept that the case law says on the facts of the case, but actually they give no meaning to those words, because what they are, in fact, pressing on this court, and what they pressed on the tribunal below, is an approach where you identify, as my lord the Chancellor said, the elements of the tort which will be common ground. And then you ask, in the abstract, well, what is the most significant element for this type of tort? Oh, well, it's a competition claim, it must be the restriction of competition. That's what the tribunal meant when it said, in the abstract or on the facts of the case. That was the nature of the dispute before the tribunal. And we say that the tribunal was right to say that that is the incorrect approach. It's not an abstract assessment. You need to look at all of the elements, where they took place, and then assess significance. So back to Deutsche Bahn. And if we could...
Do you want to look at anything else in Deutsche Bahn?
Yes, so I'm going back to Deutsche Bahn, thank you. So if you go to page 996, and this is why my learned friend's wrong to say, oh, we're advocating some different approach to Deutsche Bahn. So if you look at paragraph 52, the next task is to identify the country in which each of the elements described at A, B and C above, that's again, decision of the Association of Undertaking, restriction and loss, occurred. And going to my Lord Justice Green's point, it says here neither side has suggested that the element of a potential effect on intra-EU trade needs to be assessed, so that seemed to be common ground in that case. But this is the same approach as that laid down in subparagraph 6 and then applied in Morin and by the Supreme Court in VTB. So you look at each of the elements, or the events giving rise to the elements, and you say, where did they take place? And then you have a lengthy exposition of that question. And so if you look at paragraph 55, so you've got the heading above 53, location of the restriction of competition. And then at 55, the restriction of competition took place in each market where the relevant claimant operated its retail business. So for each claimant, there was one. Then location of loss, that took place in the country in which the merchant was based at the time of the transaction. And then you have location of the setting of the MIF, which is Belgium. So again, you see each of the elements being located in a particular country. And then if we go through to page 1006, paragraph 109, the third of the court's task is to decide, on the basis of what's admittedly a value judgment, in which one of the countries identified by reference to the discussion above did the most significant elements in relation to the tort in question occur. So again, that's wholly consistent with our approach.
And again, in the light of the facts of the particular case rather than in the abstract.
In the light of the facts of the particular case. And the key points of difference, as I say, there are two key points of difference. The first is because, as I said, for each merchant's claim, there was a single place where the restriction of competition took place, the place where the merchant was based, on the basis that's where their acquiring bank was located.
Sorry, putting the question that way, which I see matches the way you put it, can you ever get to an answer which, would you ever reach the conclusion that the most significant elements in relation to the tort in question occurred in a number of countries?
Well, no, I think you couldn't, because if one element of the tort, well, you could, I think, my lord, on this basis. So if one were to say, because it's an evaluative judgment, so if one were to say, well, the restriction of competition took place in 10 different countries, and loss occurred in 1 or 2 countries. Therefore, so it's not, you don't inevitably end up with one of the countries where loss was suffered, because you're looking at everything in the round. But you are asking yourself the question.
I mean, I suppose I'm trying desperately to make this clear, but do you say which one of the countries has most of the significant elements
Yes.
of the tort in it?
That's it.
Or do you say, I must identify the most significant elements of the tort, or the facts, and then ask where did they occur? Because that could be answered in some cases in one country, and in other cases it could be in a number of countries, and then what do you do? And I think you do say it's the former.
We say it's the former, and that's exactly what subparagraph 6 says of VTB, and that's what the Court of Appeal did in Morin. So the Court of Appeal, as I go back to Morin, it didn't say, which is your second alternative, my lord, it didn't say the most important element of a negligent misstatement case is reliance. Therefore, where did reliance take place? So when it took place in both countries, let's see where the most significant bit of reliance took place. It went through all 3 elements of the tort. So it's the first of your 2 alternatives. And that does absolutely, if I may say so, crystallise the dispute between the parties. And the way it was characterised by the tribunal, so the second alternative, which is MasterCard's case, the way that was characterised by the tribunal was an abstract exercise, and you can see why.
No, in fact, on the facts in Deutsche Bahn, what he arrived at, the answer he arrived at, which is the 124, is that the most, in effect, the applicable law would be a whole series of different laws depending on where the particular merchant claimant was based.
But for each merchant, it was
for
one.
each merchant, because it wasn't a collective claim.
Yes, so for each merchant, it was a single place, though, because for each merchant, there was a single place.
Sure, I understand that point.
Yes. And so that's the critical point. If you take a merchant, I think the comparison is between a merchant who had his own claim in Deutsche Bahn, and let's for the moment ignore the fact these are collective proceedings and take a single class member. Let's compare those. So for a merchant which had its own claim in Deutsche Bahn, the restriction of competition and the loss took place in one and the same country where the merchant was based. That's not the case here because it's an indirect claim. So for a consumer, for one class member, so imagine it's an individual claim and not collective proceedings for the moment, then that class member, the restriction of competition took place in potentially multiple different countries, depending on where they made the remote purchases from. But all the loss was suffered where they're resident. So that's why the cases are so different on the facts. So it was an easy case, Deutsche Bahn, in fact.
See, the curiosity of this is that when you get to paragraph 121, where Mr. Justice Barling draws it all together, he says, in my view, based on the value judgment I'm required to make, the most significant events in the tort alleged in the present case is not the loss, significant though that it is, nor is it the setting of management of the MIFs, it is the restriction of competition. So, you know, he seems to have stopped asking at this stage anything to do with country. He is focusing on the torts alleged and the identifying the most significant elements.
My lord, I agree, but then if you go to paragraph 124, he then
I think
says...
he then goes on later in 121 just to say, well, competition occurs on the markets.
Yes.
And the material markets, each of the national markets for providing and acquiring services. And although he doesn't, as it were, spell that out and say, which means that there's going to be a whole series of applicable laws depending upon which national market it is. That's what he means.
Yes, yes, and then, but then if you go to 124, you see again that he does place weight on where loss was suffered, so he doesn't leave that out of account. So going back to my Lord Justice Snowden's question, I agree that there is some inconsistency, my Lord, between paragraph 121 and the task that he set himself in 109. I do agree with that.
And indeed, at the beginning of 124, the paragraph you just mentioned, I mean, you focused on the last sentence, but actually the first sentence exhibits that same.
It does. I'm not going to deny that. It does exhibit an inconsistency, but it is an inconsistency, and in a sense, the fact that there's an inconsistency doesn't help either side, because he certainly says what he says at 109, and we say that's the right approach, given how the Supreme Court and the Court of Appeal have approached the case. And then going back to the two alternatives.
It really doesn't matter in the merchant case because everything happens in the single member state.
It does.
That's
The restriction, the
problem.
effect, the causation, the loss.
Yes.
That's the problem. It worked in Deutsche Bahn, and perhaps didn't matter, but it may well be. It may well matter in our current case.
My lord, yes, but that's why we're here. So,
Yes, I know.
that is, but the going back to my lord's two alternatives, and which I say with respect does precisely crystallise the debate between the parties. So we're team one and MasterCard are team two, as it were. And
I've got that.
you've got that point, but can I just make an additional point in relation to why the second alternative is wrong? Because if you have a single claim, so you have a single claim and you're trying to determine the applicable law that that applies to the claim, and my lord put to me, well, can you never end up with multiple answers? And the answer is, that's correct, you should never end up with multiple answers because you are seeking to establish the applicable law that applies to the claim. And so if there are multiple different places where the tort happened, you still have to pick one. Ultimately, you still have to pick one, and that's why you do need to make this evaluative assessment of significance based on where all the elements of the tort took place. So, I said I would show you. Protea, but maybe you've got the point because, in fact, we can probably take it from Deutsche Bahn. I think the same point is made.
It's that very short passage.
It's that very short passage, and what the court said there. Mr. Justice Barling says the same thing, is that the same type of tort can yield different answers. And if my learned friends are right, that can never happen. If one is asking, if you're in alternative two and you're asking in the abstract, what's the most significant element of the tort, it's always going to be, on my learned friend's case, restriction of competition. Now,
It's paragraph 41, isn't it? Of Deutsche Bahn.
It's paragraph.
Where he quotes Mr. Justice Moorbeck.
That's right. I think that's exactly right. And also para 118.
In different cases, even in relation to the same kind of tort.
That's correct. Now, my lords, there's a further point that we wish to emphasise which reinforces our conclusion. As the tribunal held at paragraph 89 of its judgment, loss is what this case is all about. The claim seeks to recover damages for loss suffered in the UK by the large class of consumers as a consequence of MasterCard's MIF. Now, not only, and this is coming back to the point put to me by Lord Justice Green, not only is the case all about loss, but it's a collective action, a collective claim which seeks an aggregate award of damages. And with respect, my learned friend, is just wrong to say that the procedural mechanism of a collective action is just a wrapper. That is wrong. And if we go to Merricks in the Supreme Court, which is Authorities Bundle tab 38, page 1367.
Yeah.
So another basic feature of the law and procedure for the determination of civil claims for damages is, of course, the compensatory principle. But in sharp contrast with the principle that justice requires the court to do what it can with the evidence when quantifying damages, which is unaffected by the new structure, the compensatory principle is expressly and radically modified. Where aggregate damages are to be awarded, Section 47C of the Act removes the ordinary requirement for the separate assessment of each claimant's loss in the plainest terms. Nothing in the provisions of the Act, and then it's making a point about distribution, but just pausing there, it's wrong, and this is a claim for an aggregate award of damages, so it is simply wrong to say, as my learned friend submits, that one has to look at this as simply an accumulation of different individual claims. That's not what this is about. What the Supreme Court has said here is that has radically been modified in the Act, and what one has is a claim for the aggregate loss suffered by the class. And that is important when one is looking at the significance of loss here, because going back to the point Lord Justice Green put to my learned friend, this is loss that belongs to the class, not loss that belongs to each individual member.
Well, that's a
of the
point
class.
that my lord made a moment ago in the context of those claimants who hadn't suffered any loss at all.
Yes, exactly.
Paragraph 77, I think.
It's in the, because they're still in the class, aren't they?
They're still within the class.
They're still in the class. So 76 and 77. So 76, this is in the minority judgment of Lord Sale and Lord Legate, Sales and Legate. So I've already noted that Section 47C radically alters the established common law compensatory principle. Nothing in the Act puts it back again. And then 77, this is precisely my Lord Justice Green's point. And let's look at all of it. So a central purpose of the power, that's the statutory power, to award aggregate
This is
damages.
still within the majority.
Sorry,
Yes.
Oh, I'm so
This is
sorry.
Bill Briggs, I think. So
You're
this
quite
is-
right. I'm going to take
It's all
you.
in the majority.
It's in the majority. I was wrong about that. I'm going to
Yeah,
take
it's
you to
all
the
in the majority, this.
It is.
Yeah.
That's quite right. I'm very sorry.
Yeah, don't worry.
So paragraph 77, the central purpose of the power to award aggregate damages in collective proceedings is to avoid the need for individual assessment of loss. And then we see, then we see that there will be many cases in which some approximation towards individual loss may be achieved by a proposed distribution method. There'll be some where the mechanics will be likely to be so difficult and disproportionate that some other method may be more reasonable, fair, and therefore more just. For that purpose, and then we see that what's said there. And then if we go to the minority judgment, so 1376.
It's 94 and 95.
It's 94 and 95. Can I just ask the court to read those, remind yourselves of those paragraphs?
Sorry, 94 and 95.
Yes.
Yeah.
So it's not just a wrapper, the statute has radically altered the law. So it's not right to say collective proceedings are just a wrapper to accommodate individual cases, you do have to look at them as collective proceedings, and you have to look at the loss that's suffered as being loss suffered by the class in aggregate. And so that is a relevant factor when it comes to significance of the factors.
Without need to say any individual member of the class has actually suffered a loss.
Exactly.
If
My
the
lord,
class as a whole has suffered a loss, then it's neither here nor there. There might
exactly.
be some people in it who haven't suffered a loss at all.
My lord, exactly. That's precisely so. So that's
Presumably we don't actually have in the bundle anywhere, or do we have in the bundle somewhere your actual pleading?
I
Where
think
you
we don't.
actually state what your case is about, but presumably it follows a class theme, vibe, if you like. I mean, how does it do it?
My lord, so it does it like this. So what we say, we start with the infringement established by the Commission in the Commission decision. And that's binding as regards liability. And I'm going to come to that because that's another important point, because what it means is that the restriction of competition by operation of statute is not live in these proceedings because it's been definitively established by the Commission.
I mean, I think we've thus far been talking about a completely different question than the question about whether you look at the way that things are being argued in the particular proceedings. We haven't really got to that point yet
No.
in this argument.
I'm going to get to that argument, but
We just put that to one side.
let's put that to one side. Let me just tell you
I'm starting
straight.
with what we are talking about before we start introducing
Fair enough.
additional complications.
My lord, fair enough. So I couldn't resist the slipping my point in, but I will come to that. So we start with the binding decision. The binding decision, which we're going to look at on the third part of the appeal relating to exemptability, but that establishes that the setting, effectively in shorthand, establishes that the setting and maintenance in force of the intra-EEA MIF by MasterCard was unlawful because it set a single price, and so it didn't allow, it set a single price, it didn't allow competition on what is the fee to be paid as between acquirers and issuers. So we then have the restriction, so that's all established in the decision. So what we say is that that led to higher prices, which meant that the merchant service charge that acquiring banks paid their merchant customers was higher than it otherwise would have been had it not been for this restriction of competition. And the merchants then passed on, so these are merchants that accept MasterCard.
So I do get, sorry, I understand the way you're, the
I'm so
building
sorry.
blocks of your claims,
Yes.
but it's, I'm trying to just get clear in my own mind whether what your claim says is very much following the line that you've just been pointing out, namely it's a claim for loss suffered by the class.
My lord, it absolutely is, and this is par excellence, the case which illustrates why Parliament introduced that particular feature of the regime, because
The aggregate damages.
the aggregate damages, it would be impossible on an individual basis to seek to recover loss for each individual member of the class.
There's also an opt-out claim, isn't it?
It's an opt-out claim,
So, I mean, there are 46.5 million people
yes.
in the claim because only some people have opted out, including judges who've had to forego their £17.50 in order to hear these appeals, that sort of thing. Sorry, I'm being flippant, but
Lord Justice Snowden, I think it's still
But Lord
to do that,
Justice
doesn't he?
Snowden needs to opt out.
Yes.
But I mean, joking apart, there is no identification of the claimants anywhere.
Actually, I'm not sure that is a joke.
Nobody has identified who are the 46.5 million people,
Well, except by the class definition, which
except
is,
by the class definition.
Exactly.
But I mean, there's no need beyond the class definition,
no,
which is another reason why it's a claim by the class.
exactly. And so it is just very far from being correct to say it's just a wrapper and you need to look at individual, you need to imagine these are 46 million different claims. It's a claim by the class, and it's a claim for an aggregate award of damages for loss suffered by the class. And that's highly relevant to the question of significance of the elements of the tort.
but the way you put your, the reason I was trying to drive at this, and I suppose just for the record, I probably ought to say, I suppose I probably ought to opt out or indicate that that's what I'm
Well,
required,
I'm sure that's
that
not
I
going
will
to
do
cause-
as in the same form that
Yes.
others have done.
And strike him out of the class.
But the way you put your argument focusing on the one country point, if I
Yes.
can label it that way. This point probably doesn't matter, does it? You know, how exactly you formulate your case doesn't matter, because you would get to the same result irrespective of the ability of a collective proceeding to compensate people who actually suffered no loss.
Well,
You would still get to a if you define the question in the
Yes.
one country way, you'll get to the same result, won't you?
Well, my lord, I don't want to, in this case, I think you would. So in this case you would. I don't think in every case you would, because once you've identified the candidate countries, you still have to conduct an evaluative exercise as to the significance of the elements of the tort. And so you may have a situation where element 1 is split between 2 countries and element 2 is in one country, but you don't automatically go for element 2 if on an assessment of the facts of the case, the gravamen of the tort is in one of the countries that falls under element 1. So I just think because it's an evaluative exercise, one must resist, if I can respectfully say so, the urge to say that this approach always leads to one question. It doesn't. I think in this case, then you're right. We would say that even if one is on hypothesis 2, standing back and saying, what is the most important, the significant element of this tort, you do have to look at the facts of the case. The courts say that. And the most significant element here is loss. And that's because this is that the consumers are very far removed from the myth. Most of them probably never knew that there was such a thing as a myth. They weren't paying the myth themselves. Their claim is very far removed from the restriction of competition. They are utilising this new and radically different claim set up by the legislation, which is all about recovering loss for the class. And so, my lord, to answer your question, I do say that if you were to step back and ask on hypothesis 2, what is the most significant element of the claim of the tort in this case, which is the question you have to ask, without going through all of the elements, then one arrives at the same answer, which is loss.
But the facts of the case include, you would say, that there's a follow-on claim where restriction of competition is not an issue because that's established by the company.
Yes.
And it's a collective proceeding, it's a collective claim for aggregate damages by a class.
My lord, that's right. And
those two facts of this case are what might be said to distinguish it in a fairly major way from earlier MIF cases like Deutsche Bahn.
that's exactly right, my lord. And the reason why it's distinguished is because Deutsche Bahn was primarily a standalone claim. So it's primarily a standalone claim.
It was claimed by merchants as well.
It was by merchants. And so you have, so it's primarily a standalone claim, so restriction of competition was live in the proceedings. That led to one country for each merchant, for each claim. Those weren't collective proceedings, obviously. And so you don't have, you're in an entirely different situation to here, where the claim is really about loss, because it's a follow-on claim, and it's about loss to the class. And if I can just deal with the point put against me, so the point put against me in relation to our reliance on the fact it's a follow-on claim. So first of all, let me make the submission, and then I'll deal with the point against me. So the submission is that restriction of competition, so even if one is going down path 2 of my lord's 2 alternatives, restriction of competition is not terribly important for this claim in tort. And the reason why it's not terribly important for this claim in tort is because it's been definitively established.
Sorry, hang on, wait a minute, surely the question is the significance or the importance for the tort. You added the words for this claim in tort.
Well, my lord, it's
It's surely all the cases we've been talking about thus far ask you to identify the significant elements of the tort
on the facts of the case.
on the facts of the case, but that's not the question you just posed, which by adding the words importance for this claim in tort, you immediately define your question in a way that
Well, you could put it the other way around.
answer.
The restriction of competition is not important for this tort on the facts of this case.
Yes, I can put it that way. And my lord, just focusing on this tort, it's a claim, the tort is a claim for breach of statutory duty, which the duty obviously is contained in the statute, and the statute provides, that the Commission's decision is binding, such that the only issues for the National Court are causation
Well,
of
that may
loss.
be right, but the tort is what?
The breach of statutory duty.
So how a claim in relation to it can be formulated or what may be binding or otherwise, at the moment I'm not sure that still complies with the test we've been looking at, which require you to focus on the elements of the tort, not the claim.
So, my lord, let me meet that head on. So let's look at the elements of the tort. So the tort is breach of statutory duty. So one has to identify what is the breach of statutory duty. So the statute provides for damages claims for breach of competition law. So the statutory duty, the statute provides for damages claims to be brought for breach of competition law.
I know, but the tort is still the breach of competition law.
That's right. So the tort is the breach of competition law.
So you're looking at the elements of the tort, the
Yes.
breach of competition law. It's not how that might be vindicated.
My lord, but it's on the facts of the case. So it's significant on the facts of the
But it's
case.
the fact that surely that means the facts comprising the tort.
My lord, yes, but on the facts of the case, a fact of the case is that restriction of competition has been definitively decided. It's not a case management point. It's not, oh, well, this might be conceded or not very heavily disputed. By operation of statute, that has been definitively decided. So I agree that the restriction of competition is an element of the tort, but when you get to so tick the box there, it is an element of the tort. But when one gets to the evaluation of its significance, which is the point at issue here, on the facts of the case.
Okay, so you're using the facts of the case to mean the case as brought in the claim, as opposed to the case, the events which occurred.
Yes.
And at the moment, I think all the authorities talk about the events which occurred that we've seen, unless you can show me it. I thought that all the ones who were looking to VTB and others talk about it's the events that occurred, not the case, meaning the proceedings. And so, the case, on the facts of the case, they mean the events that occurred, not how it's played out in some court proceeding.
Well, my lord, there are, in most cases, that will be one and the same thing, because the pleaded claim will be the facts that have occurred. So where you've got negligent misstatement, the key points that occurred were the misstatement, the reliance at the auction, and so on. So there'll be a sort of they'll be the same. So that the way that the claim has been pleaded and the relevant facts constituting the tort will be the same. So we're in a different position in this case because the facts, the restriction of competition is there as an element of the tort, but we say that when you look at the facts of the case, there's nothing in the authorities to say that you've got to shut your mind to the fact that the statute itself provides that point is definitively decided and won't be an issue. Now it's different to the point that my learned friend seeks to characterise this as a point about case management, the stage at which the proceedings have been reached, was the way she put it. But that isn't right at all, because on the facts of this case was only ever a follow-on case. It was only ever a follow-on case, nothing to do with the stage of the proceedings, and that's because of the operation of the statute. So that's an additional point, if we need it, to show why the restriction of competition on the facts of this case is not significant. And it makes sense to take account of it as a matter of principle, and it would be very odd to shut your mind to that point, because what the court is trying to do is, in these cases, what the statute is trying to do is find to which system of law the case is most closely tethered. And it would be really odd, in my respectful submission, to say that various foreign laws apply to the claim in circumstances where those laws are just irrelevant to the substance of the case. A, because restriction of competition has been decided definitively, and B, because, as the tribunal said, loss is what this case is all about.
That's really a point about applying a purposive construction to the 95 Act. What's Parliament trying to achieve in Section 11?
Yes, and it's also just applying the straightforward words, because it's assessing the significance of the various elements.
No,
And
but I'm not sure it is, sorry, with respect, I'm not sure it is applying the words. Because the point is, if you look at Section 11 and if you look at GTB,
yes,
it talks about the events constituting the tort or delict in question occur.
yes,
You know, I think the point I'm trying to put to you is the point Mr. Laney was putting, which is, you know, this focus is on the events constituting the tort and where they occur.
yes,
It doesn't at the moment, certainly Section 11, which is what we're on at the moment, it doesn't in any way, it doesn't mention the case, how the claim might be made, how the case might play out or anything. It's very much looking back to the events which are said to comprise the tort, possibly something before, you know, the relationship of the parties, or that's really Section 12, but in any event, there's no inkling in Section 11 words that you have to place any relevance to how the tort might be litigated, for want of a better expression.
my lord. Yes, I accept that those words aren't in the statute, but what the courts have said is that you decide it on the facts of the case. And so then one comes to my lord's point, which is, what does that mean? Does it mean on the facts that gave rise to the original tort, or can it relate to the facts of the case as pleaded? And we say it can relate to the facts of the case as pleaded. In most cases,
It has to, doesn't it? I mean, if Mr. Justice Morbick is right in pro ter,
yes,
and he's been followed, goodness knows how many cases, it must follow, mustn't it? Because if you look at paragraph 41 of Deutsche Bahn, he says, in relation to significance, it's clear the correct approach is for the court to consider the significance of the relevant events in the light of the facts of the case before it.
yes,
And then cites Dicey. In pro ter, which is Mr. Morbick stated, the 95 Act contains a much more flexible principle and one which might yield different answers in different cases,
yes,
even in relation to the same kind of tort.
yes,
Well, he wouldn't have
exactly.
said that if it were the case that in every case of negligent misstatement, you get to the same answer.
My lord, that's right. That's exactly right. We agree with
Because
that.
you're looking at it as it were, looking at it in the abstract.
Yes, and we
Yeah, but-
say
But
if
so I think we're on two different points here. I fully accept that on different facts giving rise to the same tort but in different factual scenarios, you might reach a different conclusion on what the applicable law would be.
yes,
In other words, one size doesn't fit all. Just because it's a misrep claim, you don't automatically select where the state misstatement was made, for example. Different cases, different facts. You might have one applicable law in one, another in another case.
yes,
That's not we're, sorry, that's not the point I was making to you. The point I was making to you is that when you started these submissions, you slipped the words claim into your formulation. And this raises the question about whether if in a particular piece of litigation, a particular issue is not disputed, that could lead to a different applicable law. And
Yes.
what I was putting to you was that none of the authorities we've been looking at focus on anything other than the events which gave rise to the cause of action.
My lord, can I,
It's a different point, I think, than my lord was
I
putting.
think I think it is a different point.
Yeah.
My lord, I think I agree it's a different point.
It is.
And so, can I answer it in this way? So let's rewind and pretend I didn't say claim. So no, because I want to meet my lord's point head on. So I want to.
Well, to be fair, I mean, it is a real, it's the point I'm trying to sort of, it is Mr. Laney's point. I mean,
It
one
is
of
Mr. Laney's point, and I'm trying to meet it
Yeah.
in my submission. She's trying to hold me to the word I use in my skeleton, but I'm trying to answer my lord's question. So the question is as follows. So the point is as follows. You have the statute, which asks for the evaluative judgment on significance. We have the court saying that evaluation has to take place by reference to the facts of the case. And what my lord's putting to me, and Mr. Laney's point, is that facts of the case must mean the underlying facts giving rise to the tort.
Right.
And we say no. So our primary submission is no, that isn't correct, because facts of the case is broader, and we say that it requires the court to look at the claim as pleaded. And we say that the claim as pleaded here is a follow-on claim because of the statute, and that means that on the facts of the case as pleaded, the question of restriction of competition is not live, and that's highly material to significance. So that's my primary answer to my lord's question. And we say that the interorum argument advanced by my learned friend, which is that every time the litigation waxes and wanes, that would lead to floating applicable laws, simply doesn't apply, because one's looking at the case as pleaded, as advanced. And we say that it would be very odd if one's looking at the facts of the case to ignore the fact that Parliament has said that restriction of competition is not live. So that's my primary submission. But we also say that we don't need this point because you have my two submissions that I've made already, which I won't repeat. The first is the proper approach, which is you look at all of the elements and find the one where the country where the most significant elements took place, and you've got my submissions on that. And the second is that even if we're on route 2 of my lord's two alternatives, on the facts of this case, loss is the most important element because it's an aggregate award of damages and because that is the purpose of this claim. So those are the two submissions. Now, if I'm wrong on the point, my answer to my lord about, and if my learned friend is correct, that case must mean only the facts, the original facts, then I can't utilise this point under section 11, but we say it is relevant under section 12.
So you just going back to absolute basics, you're essentially saying that section 11 has to be read in the light of section 58 and 58A of the Competition Act, the binding effect of decisions.
Yes.
So when you apply that in context as to for applicable law, the events or elements of the events occurred, it's relevant that Parliament has rendered them, that part of the tort irrelevant.
Yes, it is relevant because it's...
Or what you actually say is you've got two strings to your bow. Either it's relevant to section, you read section 11 differently for that reason, but if you're wrong on that,
Then it comes in section
then
12.
it comes in at section 12, which is because the words of applicability or it's a section 12 or whatever else we've been debating. Everybody
Yes.
accepts that section 12 gives you a greater flexibility,
That's right.
albeit said with a very high hurdle to get there.
Yes.
It is undoubtedly, by its nature, allows you to do something different than that which you would have done if you just applied section 11(2)(c).
That's exactly right. And
So section 11's narrow, and you get the display summary because the appropriateness test is related to the determining the issues arising in the case. So it's squarely linked into, as it were, the pleaded issues.
yes,
Yes, because to pick up these points, I mean, sorry, we're playing tag, as it were, across the bench, which isn't
no,
easy,
that's
I know.
fine, it's helpful.
But section 12 does contain wording, which at least is wording which you can latch onto more readily than section 11(2)(c), which contains no reference to the case or issues in the case or anything like it.
Yes, I accept that. We say it certainly arises under section 12. But
But section 12, if you're wrong about everything else, where you get to is you say, well, if one of the events is restriction of competition, then one of the circumstances or consequences of that event is that this restriction of competition has been conclusively determined to be a restriction of competition
yes,
by virtue of the operation of combination of the statute and the decision of the Commission.
my lord, that's right. And so if we're thinking about section 12, should I move? I think maybe it's time to move on to section 12, if that's, unless you have any further questions on section 11. So
No, I think it's fine.
thank you. So the provision, so I've got it, actually it's, all these provisions are helpfully appended to the judgment below, but you may have been looking at it somewhere else, but it's behind tab 6 on page 206. And if we look at subsection 2, and let's reflect on that for a moment. So the factors that may be taken into account as connecting a tort with a country for the purposes of this section include in particular factors relating to the parties. Now, that means in terms that you are allowed to look at who are the parties to the litigation. Otherwise, the provision doesn't make sense. You don't have parties to a tort, that's meaningless, as my learned friend sought to argue. So it must be parties to the proceedings. And thinking about the parties to these proceedings, so we have the class on the one hand and MasterCard on the other hand. Now, this provision cannot be, whatever section 11 does, section 12 is not limiting the court to going back historically to looking at the factors which underlie the tort. Because it's referring directly to the parties. Now, at some points in her submissions, Ms. Delaney appeared to say, well, you have to go back 24 years and look at the factors, the facts relating to the tort when it was committed. She had a temporal point, if you remember. So she said it's all about when the wrongdoing took place. Well, that just can't be right, because then you wouldn't have the word parties. And of course, when the wrongdoing took place, even when the Commission decision was adopted, the members of the class had no idea that they had a claim. They weren't directly affected by MasterCard's action. They weren't paying the MIF. And so one does have to look at the parties. The court is permitted to take account of factors relating to the parties or any of the circumstances or consequences of the events which constitute the tort. And it is, as you've already identified, it's a provision which does not decide, it's not a comprehensive provision, so it allows any factors to be taken into account, and these are the factors these are some of the factors that may be taken into account, but it's not an exclusive provision. And so at this stage, we say it's certainly relevant to take account of the fact that by operation of statute, the infringement of competition has already definitively been decided when looking at significance of the connecting factors.
Yeah, because you just simply say, if you, as I understand it, your argument is that if applying section 11(2)(c), you would otherwise get to the view that the most significant element of the tort was the restriction of competition, per Mr. Justice Barling's approach, let's say. When you look at section 12, you'd say, well, okay, well, so 12(1)(a) means you would get to a whole variety of applicable laws
Yes,
under the general rule. And the significance of any factors connecting the tort with another country, well, let's say where the loss has been suffered, which would, on at least under the general rule, be less important. You then go into the wording after the A and B. It's substantially more important, more appropriate, for the applicable law for determining the issues arising in the case. And incidentally, that's where you say you get
Yes.
your reference to parties.
exactly,
That it's parties in the case.
yes,
Or any of those issues to be the law of the other country, i.e. the one you've identified in 12(1)(b, then you displace the general rule. And you'd say if, by statute, the restriction of competition has been taken off the table as an issue in the case,
yes,
then that's a perfectly good reading of this section to say, well, therefore, you give effectively you opt for 12(1)(b. Because it is substantially more appropriate, because the other issue is completely off the table, it's not an issue.
And that analysis addresses the Aikins point about what you're going through the same exercise, because on this hypothesis you haven't arrived at that answer by 11(2)(c. You haven't arrived at the applicable law being English law, because loss is the most significant element, because by definition under 11 you said no, it's a restriction of competition.
that's right.
But then you come to 12 and you're engaging in a different, wider analysis than you have done under 11.
This is why at the moment I was picking up so much on the previous section that 11(2)(c) seems to be all to do with the tort and what constitutes the tort and what events occurred that give rise to the tort.
Yes,
Your focus is on what happened. That's the wrong. This seems, at least on one view, to be talking about what's substantially the most appropriate for the resolution of the case.
yes,
The
my lord,
issues in the case being the litigation.
my lord, absolutely. I mean, it's not
This is different.
exactly. So, so if I'm, as I say, the only point that this is really, my points on loss being very important because of the aggregate action and so on, that stands whatever the reading of section 11. So even if one has a narrow reading, that stands. So we're really focused here on the follow-on nature of the claim. But my lord, yes, I respectfully agree. And we say it's not just a reading of the section, it's the only possible reading, because it says for determining the issues arising in the case. So
Well,
that's,
the reference to the issues arising in the case, and then in 12(2) to the parties,
yes,
shows you very clearly, isn't it, that this is looking, at least in part, to focus on the litigation before the court.
exactly, very clearly. And there is really
Not falling into the forum trap.
not falling into the
not
forum
sure.
trap.
This is which law?
Which
Yes.
law?
Which system of law?
Which law? And my lord, so not falling into the forum trap, I accept that. But on the plain reading of the statute, it's asking the court to decide whether another law is more appropriate, another law is more appropriate, having regard to the issues arising in the case. And what one has in this case, so standing back, and I'm going to come to the judgment below in a minute, but standing back, one has this. So you start with you have the various elements of the tort that we've discussed. Restriction of competition leads to on this hypothesis, so I've lost on this hypothesis on 11(2)(c), so the applicable law is restriction of competition. So what that entails is, as my Lord Justice Green put it to my learned friend, a situation where the tribunal, in a claim which is for loss of this class, has to potentially decide a whole host of applicable law issues which only relate to about 2% of the claim. So that's an important factor that should be taken into account. Secondly, restriction of competition is not of relevance because it's not an issue arising in the case, because by operation of statute it's being conclusively determined. And thirdly, when one is looking at the laws that my learned friend said should be the applicable laws, so the laws of Hungary, France, Belgium, etc., those countries don't have any special claim on these proceedings. And the reason for that is because these aren't, this is very unlike a situation where some act has taken place in France or Germany or Hungary, which may not be unlawful under the laws of those states. We're in a totally different position where the duty is Article 101, which applies across the whole of the EU.
Well, and I think you probably also say that you shouldn't get too hung up about the fact there might be limitation defences under the laws of foreign countries, which amount to a very small proportion of the overall case, in circumstances where it actually is a collective damages case, so that the fact that certain people don't have a claim at all doesn't make a difference. So
that's quite so.
These are just the sort of rough edges around the nature of these collective proceedings, which comes in under Section 12.
My lord, exactly. And the existence of Section 12, which operates to displace the otherwise applicable law, expressly contemplates, and its existence contemplates, that there may be accrued limitation rights under the applicable law, which are nonetheless displaced. It's all about displacing the applicable law. So you can't say, it's not an answer to say, oh, well, that might result in some limitation defences being unavailable.
Well, that might be subject to the broad axe.
My lord, yes, and of course you have the point that the Supreme Court emphasised, which is that it's important to make this collective regime work. And so where one has a case where the claim is for an aggregate award for the class as a whole, for mass consumer loss suffered in the United Kingdom, all the loss has been suffered here, restriction of competition is not an issue in the case, the substantive laws of France, Germany and so on are simply irrelevant because we're talking about Article 101. The infringement, so the restriction of competition, is not connected to France, Germany specifically. It's a myth that applied throughout the EU. There is no claim, really, that those foreign laws have, and that's why it is substantially more appropriate. If the foreign law were otherwise to be a patchwork of different laws, that's why it is substantially more appropriate to apply English law. The tribunal was right about that. And I just have a couple of points to make about, that's really the gist of my submission on Section 12. And I just have a couple of points to make in response to some of the points my learned friend made on her new bundle. So, the Law Commission, can we pick that up?
Right, so just to be clear, when you say the tribunal was right about that, yes, I mean that's their in paragraph 90. I mean they said they would reach the same view under either Section 11 or if they were wrong about that Section 12.
Yes.
That's what you mean.
That's what I mean. And in fact, my lord, while we're on the tribunal's judgment, let's just have a look at paragraph 92. So, page 165. So 92, you've seen, if the law of the place where the restrictions, I'm just under halfway down the paragraph. If the law of the place where the restriction of competition occurred would be the governing law under the general rule, that's 11.2c, we have no doubt that in the particular circumstances of these proceedings, that should be displaced for the purposes of determining the issues that arise by the law of the place where the class members resided at the time they suffered the loss, i.e. the law of England or Scotland, as the case may be. And there are then a number of reasons, and let's just remind ourselves of what they are. So the issues the issues that arise in this case are strongly contested in these proceedings, and not whether there was a restriction of competition, but causation and quantum of loss. And so that is permissible because, as I've said, section 12B, 1B, directly contemplates that the court should be considering the issues that arise in the case. And liability and restriction of competition does not arise in the case. So it's obviously a relevant factor. Then we see at 2, factors relating to the parties are relevant under section 12.2. The class members for whom the claims are brought were all resident in England or Wales. The countries where the merchants that made remote purpose sales were located have no connection to them, nor does MasterCard have a connection with those countries. So it's not like the kind of case where the defendant is resident in a foreign country and commits a tort in that country that has specific treatment under the substantive law of that country. And further, we regard it as material that the relevant consequence of the restriction of competition by MasterCard for the purpose of these proceedings is alleged to be the payment of higher prices by the many millions of consumers in the United Kingdom who constitute the class on whose behalf the proceedings are brought. So, again, this is plainly a material consideration to which the tribunal was entitled to give weight. Now, all my learned friend says about that is that the place of residence of the claimant shouldn't be determinative. And we agree it's not a determinative factor, but in this case, it's a hugely weighty factor. But the tribunal didn't treat it as the solely determinative factor. It's got several reasons. And then subparagraph 3, the distinction is drawn between this case and Deutsche Bahn. And it said that application of the law of the country where the merchant was located in Deutsche Bahn led to a single law governing each merchant's claim. That's the point that I've made already. And it was only because the many merchants chose to bring their separate claims in one action that you had multiple applicable laws. But collective proceedings are a procedural regime which enables individual claims to be pursued collectively. And then we see the position here on the facts is very different from Deutsche Bahn. It's obvious that each individual class member made the great majority of their purchases in their home country. Any remote purchases would account for a very small proportion of their individual claim. If the law of the place where the merchant carried on business were to be applied, then the issue of limitation for any such individual class member's claim would be determined by the law of the place where they lived for the major part of their loss, and by various laws of other countries for small elements of their loss. And so we say that, again, that is a relevant factor. It's the factor that my Lord Justice Green put to my learned friend. So these are all weighty and relevant considerations. There is no error of law, and the court will recall that the threshold for intervention by this court is a high one, so it's an evaluative exercise. It's really only if the tribunal's gone wrong in principle that the court should be intervening.
Well, I don't think you, to be fair, I don't think you do endorse the last bit of section, paragraph 92(3), do you? I don't, the tribunal there said we do not see that there should be a different evaluation of the section 12 just because it's combining multiple individual claims in connected proceedings seeking aggregate damages. I think you do say, actually, that's too conservative. I think you're saying, actually, that is a relevant factor.
Well, my lord, we read that as being tied to the previous point about the limitation.
That's right, isn't it? It's putting the other way around.
Exactly.
What they're saying is, if there were individual claims, then clearly Section 12B was English law. We don't think the answer should be any different because it's a collective claim. I think you would say Section 12, it's a collective claim, therefore definitely Section 12, and it doesn't matter what the position would be in relation to individual claims, might or might not.
Yes, so he's putting it the other way around. He's saying that if you had individual claims, it wouldn't be. It would clearly be more appropriate for limitation to be decided according to one system of law, and it shouldn't be worse if it's a collective claim. But then we also see, just on my lord's point, that the tribunal does take account of the fact that this is a collective claim. We see it too. We do regard it as material. That these are the purpose of these proceedings is to be the recovery of loss for in respect of higher prices paid by the many millions of consumers who constitute the class on behalf of whom the proceedings are
I
brought.
see how you read it. It's a slightly, perhaps just a slightly way of
Slightly opaque
Yeah.
passage, isn't it?
Yeah.
So, my lords, we say that there is no error in the evaluation, and standing back, it's clearly the right answer because for all the reasons I've given. Now, can I just now move on, unless you have any questions? Oh, I'm sorry, I was going to deal with the Law Commission and the cases relied on this morning by my learned friend. I can deal with those quite briefly. Now, if we turn up the Law Commission, so it's the new bundle. And it's, I think, behind the second tab. And we make 2 points about this. So the first point is that my learned friend's submission that the impetus behind all of this was making sure that cases where the parties have chosen a governing law in relation to a contract and the tort is sort of adjacent to that contract, that provided the impetus behind the change, and that's just wrong. We can see at the top of page 13 that the impetus is much broader. So the rule of displacement was intended to cater for the situation where the tort viewed as a whole had a much closer connection with the law of a country than the one selected by the general rule. And the reason that the sections further down the page, the paragraphs relied on by my learned friend, are simply saying that there's an amendment that had been made to remove a restriction to the adjacent contract being taken into account, which is a very different point.
The one which is put at 14 in D Roman 2 is having regard, amongst other things, to factors relating to the parties and to all of the surrounding circumstances.
Exactly. So it's obviously it's wrong. It's just wrong to say the impetus behind this is concerned with the very narrow point that you've seen in some of the authorities that my learned friend took the court to. And if we go back to the previous...
The essential point is that may have been one of the causes for the change, but the language of the Act is drafted more broadly. It's not limited to collateral tortious points contingent upon the existence of choice of law.
That's right. And so that's one possible circumstance. It may be an obvious circumstance. That's maybe why most of the cases are addressing that circumstance. But the legislation has been drafted more broadly, as we've seen, and the impetus, if one is looking at the impetus, it's a broader impetus. And if we look at if we go back to page 12, some examples are given here of where a rule of displacement might be appropriate. And if we look at the second, where, for example, a group of friends, all from this country, take a motoring holiday in Europe, the parties' connection with each other prior to the tort committed by one of them against another may make it appropriate that their rights be regulated by our law. And so what one's looking at there is a situation where a group of friends from England go to, say, France, and a tort is committed in France, and it may nonetheless be more appropriate for English law to apply. Well, we would say that that's illustrative, first of all, of the broader impetus behind the statutory regime, but secondly, the present case is rather analogous, because the restriction of competition may have taken place in multiple different countries. The decision may have taken place in Belgium, but here, these claimants are all claimants, are UK residents, 46 million of them, and we say that that it's an analogous example to the one in subparagraph 2. So definitely, the submission that this is all about contract is wrong. Both the legislation and the impetus behind it were much broader. And then there's also the Batterina case in the bundle, and can I briefly show you that, because that is a case about contract. It's 4 tabs back.
Yeah,
And it's a Court of Appeal judgment. And the reason I'm showing it to you, because it's a case about misrepresentation in contract. So in a sense, it's a case which is of the ilk of those relied on by my learned friend. But I just show it to you for this reason. If we go to paragraph 55, which is on internal page 226, what happened in that case was that the misrepresentations led to the parties to conclude an agreement which was governed by English law and loans which were governed by Russian law. So the misrepresentation led to 2 separate agreements. And if you look at 55, the factors relied on by the judge are not, in my view, factors which significantly connect the relevant tort with Russia. And then it says, I've not ignored the fact that the misrepresentations are said to have included both the agreement and the loans, which are governed by Russian law. I don't regard that as making a significant difference. The loans are themselves pleaded as being made pursuant to the agreement, and no claim is or could be made to rescind or claim any relief in respect of them. And the reason I show you that point, or that paragraph, is because here is the Court of Appeal looking at the issues in dispute between the parties, looking at the facts of the case. Where's the greater connection? Yes, the misrepresentation also led to the loans, which were governed by Russian law, but the dispute, that they're not central to the dispute.
Yeah.
So those are the points I wanted to make about section 12, and I'm left to deal now with common law, and I may have to go over the short adjournment. I hope to take it quite quickly, but I've had much less time, I hasten to add, than my learned friend, so I've done my best to shorten things.
It's very impressive. And I think we probably sort of caught up, and we all have we? Or are we still behind?
I need to have a look at the timetable. We may have almost caught up. I've done my best. Can I make
Because we will need to have a think about, obviously not now, but certainly at 4:15 and 4:30.
Yes.
What time we said tomorrow.
My lord, I understand that. Let's take stock at the end of the day.
Let's take stock at the end of the day. Okay. Get started on.
I'll get started. So double actionability. MasterCard has 2 distinct grounds of appeal. The first is that the tribunal erred in finding that the tortious act can't be located in a single jurisdiction for choice of law purposes. And the second is that the tribunal erred in finding that the exception to double actionability applies in these proceedings. So I'm going to address ground 1 quite shortly. So we say not only is the argument wrong, but it's very difficult with respect to see where it goes in this case, because the tribunal proceeded on the basis that the rule of double actionability applied, such that it was necessary to consider whether to apply the exception. And so really the key area of dispute is whether it was right to apply the exception. But as to the substance of ground 1, if we go back to the judgment, so core bundle tab 6, page 168,
Yeah.
and if we look, 169, let's take it from there. So paragraph 96, Deutsche Bahn is, so the part of Deutsche Bahn that also considered the common law and double actionability is set out here by the tribunal. And you can see that Mr. Justice Barling said that the lex loci delicti should be treated as the place where all the effects which Article 101 is aimed at preventing, the restriction of competition where each merchant operated. That's also the place where recoverable loss was allegedly suffered and is the centre of gravity of the tort. And then the operative paragraph for the tribunal's reasoning is the following paragraph, paragraph 97. And what we see in paragraph 97, in fact, may I just ask the court to reread paragraph 97? I think that's the most efficient way forward. So the first point to note is that the tribunal is proceeding on the basis that MasterCard's right that it's the restriction of competition that counts for these purposes. So it's saying, well, what happens if we apply the Deutsche Bahn position? So it's not saying, oh, well, the tort substantially took place in the United Kingdom, therefore we don't get into double actionability. That's otherwise it wouldn't have had to have applied the exception. And so then it's right to say, we say, that each class member's claim in tort against MasterCard concerns all of that individual's purchases. Because, as I said earlier, the class members have a claim in tort against MasterCard arising from its infringement of competition law, which is the setting and maintenance in force of the EEA MIF. And they suffered loss as a result of that infringement every time they made a purchase from a retailer that accepted MasterCard. So those are instances of loss flowing from the same continuing breach. And the claim seeks to recover damages. And pausing there, it's meaningless to say every time there's a purchase, there's a separate breach of competition law, because there's a disconnect between the purchases made by the class members, which because they're indirect purchases, are down the line. So this is all loss flowing from a single continuing breach by MasterCard. And the claim seeks to recover damages in respect of loss arising from all the class members' purchases, including, of course, purchases made from domestic merchants, as well as merchants in several foreign countries. So that's the proper analysis, as the tribunal held, of each class member's claim. And then what the tribunal did was assumed, as is MasterCard's case, that the tort was committed at least in part in the countries where competition was restricted. So in other words, in the country of the merchant's acquiring bank. And then it said, well, applying on that basis, so if it's the place where competition is restricted, then there's going to be several answers to the applicable law question for each merchant, for each class member's claim. And that's plainly right. It's the point we traversed earlier on. And I've shown you also what the tribunal said in its judgment refusing permission to appeal at paragraph 16, which is along the same lines. Now, MasterCard's argument, and this is paragraph 58, is that the court must analyse each of the class members' claims on the basis that they comprise particular tortious acts depending on the place from which the class members made purchases from foreign merchants. So they say there's claims which relate to France, claims which relate to Germany, and so on and so forth. But this doesn't meet the tribunal's point, because MasterCard's position is, well, there's a single answer for claims made by a class member in respect of purchases, remote purchases from France, and a different answer for claims made from Germany. But that doesn't meet the tribunal's point, which is that for every class member, there'll be a patchwork of applicable laws. That was the point that the tribunal was making. And so we say that this ground of appeal is ill-founded, but more than that, it's just impossible, as I say, to see where it goes, because the tribunal proceeded on the basis that double actionability was engaged and it would need to apply the exception, which is what MasterCard contended for. So it's difficult to understand the ground of appeal. It's wrong and it doesn't really go anywhere. Should we pause? I think it's going to take me long. It's going to take me about 10 minutes or so.
Say 2:05 then.
Court rise, if able.